Good morning and welcome to this session of the Massachusetts Appeals Court. It is my great privilege to be sitting today with Justices Englander and D'Angelo, and my name is Gabrielle Wolohojian. I'm going to go through some basic ground rules for everyone in case you have not appeared here before. Each side receives 15 minutes to argue. There is no rebuttal, so don't reserve time for rebuttal. The yellow light will go on about a minute and a half before the end of the 15 minutes, and that's to allow you to know that it's time to think about how you want to wrap up your argument. And when the red light goes off or goes on, your time is up. So unless you're in the middle of answering a question by us or we ask additional questions, that is when your argument will end. You need not take the entire 15 minutes if you don't need it. It's a limit, it's not a floor. The panel has read the briefs and the appendices and the other materials that you've submitted, and we're familiar with your arguments and the facts. So you don't need to waste your time. You can construct your argument in any way you'd like. However, you don't need to feel like you need to educate us on what your case is about, because we are familiar with it. And with that, I am going to we're going to be taking cases a little bit out of order. So this case was originally the second case on our list for this morning. It is case number 2022P0443, Commonwealth versus Jeffrey Wheeler. And is it Attorney Kathawala? Did I pronounce that anywhere correctly? All right, pretty good. How is it? What is it really? It is Kathawala. Kathawala. Okay, so we're ready whenever you are.
Well, good morning again, Justices. May it please the Court. There are two issues I'm presenting today on behalf of Mr. Wheeler. The first and I would say most significant issue.
Do you mind speaking up?
Oh.
Yeah, you can move the microphone, but there's actually no substitute for projection.
Okay. Thank you, Judge. The first issue before the Court is actually the interpretation of the term or the word clerk, small c, clerk. And the second issue I would suggest is whether or not there was sufficient evidence to find that Mr. Wheeler intimidated both Ms. Mieja and Judge McCabe. With respect to issue number one, with respect to the term clerk, I would suggest to the Court the statute does not, of course, define the word clerk. That is the statute of witness intimidation. However, and as you have stated, you've read the briefs and you're familiar with my argument, I would say that the term clerk is defined in Chapter 218, Section 1.
You made that argument in your brief, but when I look at that definitional section, it says that those definitions apply to that chapter.
Okay.
Do you see that?
Right.
I mean, if you look at that, so do you have a case that you can give us where in the face of language like that, we nonetheless apply that definition to a different chapter?
Well, Judge, I would suggest that the State Board of Retirement versus Bulger again talks about a clerk and talks about the duties of the clerk.
My question, I think, was slightly different.
All right, I'm not quite sure then
Okay, I'm oftentimes ask unclear questions, so we'll straighten that out.
Okay.
Chapter 218, Section 1 has a definition of the term clerk.
Right.
However, at the beginning of that section, it says that the definitions are for those words as they are used in that chapter, which is chapter 218, which is not the chapter at issue here. Instead, we're under chapter 268. So my question to you was, do you have a case saying that where a statute defines a word and says that the definition is for that chapter, we've then nonetheless taken the definition and applied it to a different chapter?
No other cases other than I guess what I would say to you, Your Honor, is I used that as illustrative as to the duties of a clerk, since the intimidation statute does not say
But
or
the
define
intimidation
what the
statute
clerk
lists,
is.
the intimidation statute lists a number of positions that are associated with the administration of justice, right?
Yes.
In its various forms. Why would we construe the word clerk to not encompass someone who is taking calls from the public to administer the court system, to help administer the court system?
Well, for one thing, I would say that Ms. Vieira, by her own admissions, did not say she was a clerk. She said she was a case specialist, and that's stated a number of times.
Position does not come with the word clerk.
I didn't hear that, Judge White.
You're saying her position does not come with the word clerk attached to it as a formal name.
Yeah,
But
correct.
she's in the clerk's office, that's undisputed, right?
Right.
She's taking calls from the public in
Correct.
order to aid in what the clerk's office does. Why would we construe the statute? Why would we think the legislature wanted to exclude someone like this from these protections? Aren't they subject to the same kinds of concerns, that they can be intimidated, harassed, punished, threatened?
Well, then, if you look at it in that light, anyone that is in the clerk's office then is a clerk, and that means almost, well, the entire district court staff then would be a
Well,
clerk.
I
And-
tried to limit what I was saying
Yeah.
to someone whose job involves taking calls from the public. So I'm not talking about anyone, I'm talking about a person in that role.
Well, again, I would suggest to you, she's just taking a call. Does that make her a clerk, as defined at least in other statutes, or in the Bulger case, when they say a clerk gives oaths, signs warrants, has show cause hearings? So again, I would suggest, she says she's a case specialist. It sounds almost as if she's a secretary.
Was there testimony as to what her duties were as a case specialist?
She said she answered the phone, she took notes, she would copy papers. If people asked her for papers, she would mail them out, and she did some filings.
Like court papers? You're
it was-
talking about court papers?
Right, it was never defined within the transcript what papers they were. For instance, although she was in the clerk's office, she really had and recall, she was only there for 1 year, she had no real recollection of interrogatories, filings. She knew a little bit about in-hand service, but she talked about, well, I think you need a constable for that. That was also in the transcript. She never was defining her role other than those.
Oh, but it appears to you that part of her duties entailed doing things with court filings, things that had been filed in court, papers in the clerk's office.
Correct.
Intaking paperwork, processing paperwork for the attorneys, customer service. I just quoted from what she described.
Okay, so I realize this may not be the way the case was tried, because it appears to have been tried under subsection B3C? No, yeah, C,
BB, yeah.
which is clerk. But I'm wondering about, do you have the language of the statute in front of you?
I do.
Okay, so I'm looking at the preceding subsection, which is B, person who is or was aware of information, records, documents, or objects that relate to a violation of a criminal law or a violation of conditions of probation, parole, bail, or other court order. And I take it the way this case was charged and tried, the government did not claim that this employee fell within that subsection?
It was not tried in that way.
Okay.
And there's, I'm sure you recall, there was a stipulation that Judge McCabe was a judge. So the
Right.
issue really was, what was Ms. Mieja?
Can we,
Yeah. Okay.
can we switch gears for a moment to the sufficiency of the evidence as to the charge that related to the judge? As I understand your argument, it plays off of the argument that was, the factual argument that was made to the jury, which is that this was a mistake, that your client was not threatening the judge, that your client was calling up to say, I want you to tell the judge that I'm going to try to file a formal complaint against her.
Yes.
Okay, but don't we, I mean, what's your best argument for why we're not left with that being a jury question, given the nature of the testimony? Ms. Mejia said at least twice, at first I thought he was saying robe, and then as I listened to him, I decided that he was very repetitive, was saying, I'm going rogue. And isn't that enough to raise the concern reasonably that he's threatening the judge?
Well, I would suggest it was not. As you read in the closing argument or in the opening of Mr. Allison, he says this is a game of phone tag. If you recall what Judge McCabe said, she said, oh, I understood at sometime when the trooper arrived that there had been a threat on her life. That was a statement she made at the court. It's, I think, around page 151, 152. But I'm going back to, first of all, how was Ms. Mieja intimidated? And then I move on to...
I want to make sure we're talking about, there are two counts. There's one that involves a threat to the judge and one that involves the threat or intimidation of Ms. Mieja.
Correct.
Talk about the count on the judge.
Okay.
You say there's insufficient evidence. And as I understand your argument, it's basically, look, everybody misunderstood. It was an unreasonable interpretation of what your client said.
That is essentially a major part of my argument. If you go to the end and see Judge McCabe had no knowledge of any of this until a trooper came, and as I said, page 151.
Does that matter?
And said, well...
Does it matter if Judge
does
it matter what Judge McCabe had knowledge of? I mean, the statute says directly or indirectly threaten the judge, right?
Well, doesn't she have to be intimidated in some way?
No, I don't think so. Not the way I read it, not the way it was charged.
Okay.
Directly or indirectly threaten to punish a judge for an action that she took in a civil proceeding would be sufficient, I think, wouldn't it? And I think that's the way the jury was charged.
Yeah, well, then again, service in...
Well, am I wrong about that? That's the way I read the statute.
No, you're right, that's what was charged.
It seems like you're trying to argue that the defendant's intent was different than something that the jury found. And to echo what Justice Englander was saying, that's a jury question, isn't it? They didn't believe your client that that was his intent, just to serve papers. They believed that his intent was to threaten or punish the judge in some way. So how do we overturn that?
Well, how would going a step further, what would have been the punishment? serving the judge? I mean, there was no statement by Mr. Wheeler.
He doesn't
that
have to
That's,
sit.
that's
May
if
have.
they believe your client.
Right.
If they don't believe your client, it had nothing to do with serving papers. It was, I'm calling to threaten the judge for what she did. That would be a fair interpretation of what the jury could have believed.
Well, I think they could have believed that what Ms. Mier has said. Originally, she said he was going after the robe, and then
Okay,
she
so-
said, oh, it was rogue.
So as I'm sure you know, we are going to be bound by the law that says that in evaluating the sufficiency of the evidence, we take the evidence together with the reasonable inferences to be drawn from it in the light most favorable to the Commonwealth. It's helpful to us if your argument on sufficiency stays within the legal framework that we're going to be bound to accept.
I didn't hear that last part, Judge.
It's helpful to us if your argument on sufficiency stays within the legal framework that we're bound to accept.
Well, yes.
So, okay,
I understand the argument, Judge, yes.
all right.
Can I go back to the statutory construction a little bit?
Yes.
268.13 Big B
Yes.
lists a group of individuals, and some might read that statute to say that those individuals play somewhat an active role in something to do with a case. A judge has an active role. A juror clearly has an active role. The way you want us to read it, you want us to be exclusive to a clerk. And I don't know how much work you do in the district court, but clerks of the court generally don't sit in the courtroom. They play an administrative role. So under your theory, even an assistant clerk who calls the case, is in the courtroom, wouldn't fit into this definition? Is that what you want us to find?
Well, I would say an assistant clerk is part of the clerks or clerk definition if you, for instance, so that's what I would expect you to find, like a
So
clerk and assistant.
an assistant clerk fits into this definition even though it only says clerk?
I would say that you could make an argument that it does.
How?
By-
Under what
because-
you argued in your brief?
Well, because they have ministerial duties that are, that relate to the courtroom. They can find and do and have clerks' hearings, motor vehicle ones, for instance. It's not the clerk who hears it, it's an assistant clerk. So they, certainly a case specialist cannot and is not given the duties of having a clerk's hearing. But an assistant clerk, and all the assistant clerks then have quasi-judicial ministerial duties. So that's why I would suggest that it fits within the term clerk, whereas a case specialist has no quasi-judicial authority. And my time's up.
Thank
Yeah,
you.
may I ask a question? Is there any way from the record that we've got that we can tell which intimidation charge related to which person?
I don't think so. It was, I mean, I think Judge Del Vecchio was trying to get the parties to ascertain where.
Well, there were verdict slips with the names on them.
Yes.
Did anyone make an effort to include the verdict slips in the record for us?
I did not.
Okay. Do you otherwise know which charge was for which person?
I do not.
Okay, thank you.
Those I did not see.
Okay, thank you.
Anything?
Let me see. No.
Trial transcript 2-122 might answer our question.
Good morning. May it please the court. Marina Moriarty on behalf of the Commonwealth. Justice Wolohojian, to address your last question to counsel, I am happy to provide the court with the verdict slips and the complaints in this case if they were not part of the record appendix. I will make an effort to diligently get that to the court.
Counsel, perhaps on the trial transcript at 2-122, at least the clerk reads, on count 2, intimidating a court official, Judge Mary McCabe, after the jury returns a verdict of guilty, etc. Can we read from that count 2 is Judge McCabe as the quote-unquote victim?
Yes, Your Honor, and I think a couple of pages before that, you can, page 2-120, complaint number wherein the defendant is charged with intimidating a court official, Annabelle Mejia, that would be consistent with that being count 1.
Okay.
All right, so then, can you tell me what the sentences were on each of the counts?
I can, Your Honor. So on count 1, the defendant was sentenced to 1 year in the House of Corrections, deemed served. And on count 2,
I'm sorry, the docket indicates 2 years on Record Appendix 4. All right, so you said 1 year. The docket reads 2 years House of Correction on count 1, and on count 2, it says 1 year House of Correction suspended until 11/10/2022.
yes, it was a suspended sentence as well. That is correct, Your Honor. Thank you.
Okay, just want to make sure we're all on the same.
Can we, if my colleagues don't mind, let's jump to a question that I'm concerned about. Under what reading of this statute was there a violation with respect to Ms. Mejia, and how do you justify that?
So I think, so Section 13B, little b,
Yep.
I think either subsection 1 threatens or intimidates or harasses.
So where was the threat that was made to Ms. Mejia? What's the threat that was made to her?
I think it was an indirect threat to her based on his threatening to go rogue with respect to Judge McCabe, who is in the same courthouse as this woman. I think that the better argument is that he intimidated or harassed her, which I think is what I focused on in my brief.
Okay, so harassment requires that it's defined term, right? Requires that it be directed at her?
Yes, and it's an
And
objective.
how was this directed at her? It was very clear from from all the testimony that it was directed at the judge, not at her, right?
Well, I don't think it was his anger and frustration and the tenor, and the reason he called was because of Judge McCabe, but he was clearly speaking, and there's no dispute that he was speaking to Ms. Mejia.
So if you answer the phone and you take, someone is threatening someone else, that's also a threat to you that violates this statute?
No, Your Honor, I think you can be harassed by picking up the phone, answering the phone, and trying to do a...
No, but harassment is a defined term. And I don't have it directly in front of me right now,
It
but
says to engage in an act directed at a specific person or group of persons. Here, that specific person would be the judge. It was directed at the judge. That seriously alarms or annoys such person or group of persons and would cause a reasonable person or group of persons to suffer substantial emotional distress.
Yes.
So I think the argument you just made, or the of interpretation, doesn't really fit squarely with that language.
I certainly think that a person who picks up a phone and is an intermediary between the complainant and a judge can be harassed based on the conduct of the person on the phone. And in this case...
So what evidence was there that what the defendant said on the phone was directed to Ms. Mejia?
It was perhaps indirectly directed at her, but she was the one who answered the phone. And he told her, take this down, tell Judge McCabe, make sure you're taking notes in an aggressive, repetitive fashion. And so based on
Right.
her...
I understand your argument that it's indirect, but the problem with definition of harassment is that the indirect language is not included. In the definition of harassment, it's an act directed at a specific person.
Well, he's directing her to do something. He's directing her to tell Judge McCabe these things. He's directing her to take this down. He's directing her to pass on a threat.
You know, the problem with the way you're reading it is that we have clerks in the clerk's office who take calls all the time from people who are seriously annoyed about something that has happened to them. And, you know, I'm having trouble finding any bound to your argument that doesn't mean that someone who's upset when they call the clerk's office isn't engaged in a crime.
I would say that that's where the objective standard comes in. There's the subjective standard that the person who answers the phone has to be seriously alarmed. But there's also the objective standard of, I would suggest, it's a reasonable person in the clerk's office. Would a reasonable person in the clerk's office become seriously alarmed? And again, that is...
But you see, part of the protection against, to my ear, reading this statute, part of the protection against my concern is the language directed at a specific person. The testimony in this case was that this was directed at the judge. Please tell the judge this. I'm going to do this with respect to the judge. Right?
He was directing Ms. Mejia to do something with respect to the judge.
Okay.
And I also...
Can we turn to the issue of whether she's a clerk within the meaning of the statute? And I have
Can I just say one more thing on that, on Justice Englander's point?
Sure.
There's also the intimidates verb, and I do think it's either threatens or misleads or intimidates or harasses according to the statute. So I think that...
Okay, so intimidation is somehow going to be construed to be broader than harassment. It doesn't have to be specific, it doesn't have to be directed at her to be intimidated. That's got to be, that's the only way I think that in order to draw the distinction you just did, I think you have to say that intimidation is broader than harassment.
I think it might be, Your Honor, under the case law.
I understand the argument.
Who is not covered under the statute, under your definition of clerk and judge? And I mean, it seems like anyone who works for any of these entities is covered by this statute, which would, and no offense to anyone, it includes a custodian.
I was just going to say, Your Honor, I don't think a custodian would be necessarily protected under one of these classes. They might be protected in another class as a potential witness or person with information, but a custodian who just happens to be walking through the clerk's office and picks up a phone, I don't think that person would be protected because they're not under the auspices of the clerk's office. They're not doing the court's business. They're not in the process.
All right. To me, I'm just going to read the language of the statute. Whoever willfully, I'm going to excise the portions that don't apply in this case. Whoever willfully, either directly or indirectly, misleads, intimidates, or harasses another person who is a clerk. Singular. It's in the singular with an indefinite pronoun. But it doesn't say an employee of the clerk's office. What is your best case to say that we should interpret a term, a singular term in a criminal statute to encompass a class of people? I'm looking for a case site.
I think Harvard Crimson that I cited in my brief, which talks about that the statute must be interpreted according to the intent of the legislature. I think here where there's no definition provided and the word itself could be ambiguous, we have to look to the intent of the legislature.
Well, if it's ambiguous, do we ever construe that to the detriment of a criminal defendant?
If it's not so ambiguous as to not have put the person on notice, yes.
Okay, let me give you it's ambiguous. You say go to the intent. Give me something that shows what the intent of the legislature was that would include the entire clerk's office? Because I looked at the history of the legislative intent. Can't find a single thing that talks about that. Can't find any, and then if you can't find the legislative intent, you go to another statute. Point me to another statute where clerk equals an employee of the clerk's office.
Well, I think that it's the legislative intent in the amendment for the 2006 amendment, which inserted the word clerk, was clearly intended to expand the scope of the statute to include beyond just witnesses and police officers.
And it was specifically included a number of individual people or classes.
It's groups
It's
of people.
roles.
Where is it groups?
It's
Where
roles.
does it say groups? It's judge, juror, grand juror, attorney, correction officer. Those aren't groups. Those are individuals with a particular job or function.
They're individuals within a particular office in the courthouse doing the court's business, administering justice.
So if somebody says that a correction officer is an employee of a judge, because a judge is the head of the court in the district court, why doesn't, going back to what I asked you first, why doesn't a custodian fit into the class that says judge with a little j? It's an employee of the judge. Judge's secretary, custodian. Again, I'm trying to figure out from your argument who that works in the district court isn't covered by this statute under the argument you put forward in your brief.
I think many people in the district court are covered. I would go so far to say most people in the district court are covered because
It's not. I'm going back to who's not under your definition.
The judge's secretary who does not interact with the public,
Judge's secretary answers the phone for judges, just like the case specialist in this case answered the phone for the clerk's office.
I'm sorry, in my experience, I've never spoken to a judge's secretary, Your Honor. I don't think that a person who is not forward-facing, public-facing, asked to...
It's a really good policy argument. The problem is the legislature chose particular words. And for better or for worse, everyone here, we're bound by the words that legislature chooses. And they didn't say, you know, anyone who has a forward-facing role in the court system. It would be home free if they had said that, but they didn't. So I guess what I'm hearing you say is that we should construe the phrase another person who is a clerk to mean another person who is an employee in the clerk's office.
Yes, Your Honor. Doing clerical...
Forward-facing, facing the public.
Well, I mean, I would...
Well, that's what I heard you say.
I would also point out that
Who is not a custodian.
She is also doing clerical duties. I mean, to the extent that the job responsibility, you know, we're talking about the job responsibility.
Not sure there's a line between works in the clerk's office and doing clerical duties. Can we switch? I have a concern that I want the Commonwealth to think about. This statute is all about speech. It is a statute which directly regulates speech. And we have a case here where the defendant says, I was calling to complain about something the courts did to me, and I wound up being convicted for it because they misunderstood what I was saying. Now, I understand your argument's going to be it was a true threat and therefore not protected by the First Amendment, right?
Yes, Your Honor.
And that there was sufficient evidence for that, for the jury to find that.
There was sufficient evidence for that to go to the jury, yes.
Is there a de novo review that needs to be applied in these circumstances because this is a First Amendment case? I mean, this is a First Amendment case. This is not raised, but it's very concerning to me that someone is convicted under circumstances where they say they totally misunderstood what I said. I called someone who didn't understand what I was saying.
Well, first of all, the jury found him not guilty of the threat, which I think is significant. So the jury clearly adhered to their responsibility of finding proof.
Well, if he didn't make a true threat, he can't be guilty. That's under the First Amendment to the United States Constitution, he is allowed to complain about what public officials do unless he makes a true threat.
I think the elemental and statutory difference between a true threat and threatening a judge is there's different standards. There's different elements.
There can't be. I'm telling you, the law is that unless it's a true threat, it's protected. It's protected speech. Am I wrong about that?
I'm sure you're not, Your Honor, but I'm sure there's also a.
Well, I've given it a lot of thought, but if there is some line in there, then I could be wrong, but
Well,
I don't understand
I would
that.
think that in that case, then every intimidation or threats case would also be required to, the jury would also be required to find a threat, and I feel like.
I think it's implicit in the statute. I mean, we deal with this in the harassment context all the time. There's a case about it under 258E about how, when we're talking about, and I think that case of Brian is actually talking about the criminal harassment statute. It's a First Amendment case. Anytime you have a sanction on speech, you've got a First Amendment issue.
I don't think the case law is such that the jury must find the defendant guilty of threats in order to also find the defendant guilty of witness intimidation under 268-13B.
Thanks.
Thank you.
I don't see any further questions. Thank you both. It's an extremely interesting case, and we've been helped by your arguments and by your briefing. The case is submitted.
Thank you.
Okay. We'll take it. We're going to take the first case. We're next going to hear case number 2022P0151, KATRINA PIMENTAL versus CHRISTINA GALARZA. I'm going to note that the case appears to be partially impounded. I'm not sure to what degree it's impounded, but please respect the impoundment during your argument. So don't disclose impounded material, please. So, Ms. Galarza, we are ready. I think you just came in, so you may not have heard that you receive 15 minutes to argue. When the red light goes off, the time is over. We've read all of your materials, so you don't need to tell us what the case is about necessarily, but you may construct your argument in any way you'd like. So we're ready to go whenever you're ready to go.
I'm ready.
Okay, and you have to move the microphone and really speak up.
Thank you. Your Honors, you've read the case. So basically what my argument is that the electrical usage, request for timely repairs, the tenant-landlord responsibilities for the household members and guests, and the landlord's obligation to supply and maintain the apartment as per the state sanitary code was provided to the landlords in writing during lease negotiations in February 2019. 3 of the 5-page written document was provided under Plaintiff's Exhibit D, and the unexecuted lease, was also included under Defendant's Exhibit E. The high electric bills were raised February 17, 2019 during the walkthrough inspection as noted on page 2 of Defendant's Exhibit E. And in a motion to expand the case file, I included a National Grid Electric high bill complaint to support that I was raising high bill complaints as early as July 17, 2019. April's rent for 2019 was withheld in order to obtain repairs to the unit's door frame.
Which month was that?
April 2019's rent. That was included in some text messages that were allowed as joint exhibits, and the balance of that conversation was submitted under the expansion request. So April 2019's rent was
Judgment
withheld.
did not enter. That was not one of the months on which judgment entered, was it?
No, but I raised that to support the fact that I had previously withheld rent in order to remedy necessary repairs that violated the
But
state.
then you paid it.
I did
and-
upon the
and
repairs.
Can't can't we infer from that that whatever you were complaining about in April of 2019 was resolved between you and your landlord?
Yes, it was. It was resolved without the issuance of a 14-day notice to quit or the filing of an SPE.
Right. So what we have here, we're talking about, as I understand, is December 2019 and January of 2020.
That's
right?
correct.
And you did not pay the rent those months.
I withheld the rent.
You did not tell the landlord that you were withholding on the basis of conditions of your home when you did not pay in December or January, did you?
Well, because the initial arrears was the cause of a financial transition from full-time employment to sabbatical leave of absence, relying on Social Security disability insurance. The initial arrears was not because of anything to do with the conditions of the home. And I did not receive the electric bills until after the heating deficiency, which wouldn't have required any withholding upon December 1st, because I didn't have the electric bill to see how high it was. And the judgment was issued under Rule 10, I think it was 239-8A, which indicates as long as the landlords or anyone representing them was aware of the conditions prior to the arrearage, I should have prevailed under 186, 14 and 18. They were receiving notice of my high bill complaints on my electric usage as early as the beginning of 2019, which was before arrears. I didn't withhold rent strictly because the heating facilities were not maintained properly. I withheld rent trying to obtain a partial reimbursement for electrical usage, which was also supported in the letter from the SS.
So you're doing a very nice job of representing yourself. What is the condition that you claim was a violation of the lease that was existing and that your landlord knew of as of December of 2019?
It would be the heating deficiencies that prompted the use of electrical heaters in order to remedy the situation on my part. I was looking for just...
As I understand it, that was back in 2019. Were you still using those same heaters in December of 2019?
Yes, the heating deficiency was both in January and December, and the plaintiffs oversaw both repairs. And they admitted in text messages, which was submitted with my motion to expand the case file, that prior to the SPE filing, they were in possession of the receipts, the photos, and text messages supporting that they had knowledge.
So these heaters provided heat for your home, and so the condition that you were concerned about was what?
The heaters did not provide adequate heating for my home. I submitted a floor plan after measuring the square footage to support the fact that my personal electric heaters could not possibly remedy the heating deficiency with 12-degree external temperatures.
Can you point to where in the record that was submitted to us that you complained to the landlord that the electric heaters in December 2019 was not sufficiently heating your apartment? Where in the record can we look to for that?
Me personally, I didn't, there's a joint exhibit text message from the plaintiffs, and one second, where they indicated that they themselves took the initiative to purchase 2 propane heating units.
I saw that. When
It was
I
a
looked-
verbal conversation. It was not done through text messages.
So there's nothing, again, I recognize in the record
Yes.
that there was electric heaters. I got that.
Yes.
But I'm trying to find something where after the electric heaters were in, you just said December of 2019, that you complained to the landlord that they weren't heating the apartment properly. Is there any text? Is there any letter that you sent, an email, or was it just what you said
It
to
was
the landlord?
verbal. It was verbal.
And was that testified to at the trial by you, and did the landlord say something different that the judge credited it?
Can you repeat that? I'm sorry.
Sure. Did you testify to that at the trial, that you complained to the landlord in December of 2019 that the electric heaters were not sufficient?
I did, actually. I attempted to defend that, but was unsuccessful, and I did not have rebuttal evidence at the time during trial, which is why in my motion to expand, I included an extension of a joint exhibit text message, which supported that in text messages, I was complaining about the use of the heaters, both propane and the electrical ones not being sufficient. And I did try to argue to the judge that it was not sufficient because the external temperatures were 12 degrees, and I tried to submit a web browser printout of the weather conditions, but he didn't allow it.
There was a motion you filed a motion to expand case file after the trial evidence had closed, correct?
Yes, that is correct.
And I take it the judge denied that motion?
It was filed with your court. It was
Okay.
not filed with the lower court. I
Okay.
did try to file evidence for AWHR letter to support that my attempt to impeachment was valid. She
All
was
right.
not giving
So
truthful
just so you
testimony.
know, for better or for worse,
Yes.
on appeal, we can't expand the trial record.
Okay. Okay.
Because our job is to try to decide whether on the record before the court below, whether there was any error. So we're not a court that takes evidence. We need to look at the record that was submitted to that judge because we're evaluating whether that judge on the record before them
Okay.
did the right thing.
So I tried to impeach her testimony during the trial multiple times, and I referenced documents that were provided and available at the time, and the judge did know that he was going to reference them when weighing out his decision. That's where the abuse of discretion, in my opinion, or the de novo review request came in, because the findings that he put that judgment is subject to is not supported by the testimonial evidence or the documents provided. He stated that there was no there was no breach of quiet enjoyment or the warranty of habitability, but there was. And while I didn't have the violations documented, there's still proof that there was a violation of the state sanitary code continuously throughout my tenancy. And I understand completely that you can't hear new evidence, but I was still trying to put it before you because I was not properly prepared at trial. I did not expect them to be untruthful in their statements. And there is evidence that was made available to me after trial that I did submit to the lower courts that supports that her detailed testimony was in fact invalid. It was not truthful. And it's not mistaken.
If we were to agree with you somehow that what would be the relief in your view? I take it you no longer live at this property?
I do.
You do live at this
I
property?
do still live in this property. It is hard to receive a new apartment when you have an
Are
eviction
you
hearing.
paying rent?
I am. I've been paying rent continuously, and I satisfied the appeal bond. Yes. And again, I've withheld rent in the past.
Have you paid the arrearage?
The arrearage was satisfied in the appeal bond, to my understanding. That was the purpose of the appeal bond, to pay the arrearage plus additional costs, which the courts ordered. And it was satisfied in full on the 28th. Yeah, on the 28th. So on June 28th, 2021, the plaintiff's counsel received $2,095. And again, in my exhibits, which the lower courts did accept, I presented a letter from SCCLS supporting that I did go to file against them before they filed against me. They were aware that I was actively taking actions, trying to get help with reimbursement towards my electric bill. I wasn't seeking the full 2 months' worth of rent, and counsel did receive a letter upon him serving me with a 14-day notice informing him, this is not arrears. I'm intentionally holding this because your clients did not properly maintain the heating facilities, which resulted in excessive use of my electricity, which has been ongoing since the start of my tenancy. And even in the letter from SCCLS, they confirmed that I was only asking for partial reimbursement of my electric bill. I wasn't asking for them to pay the whole bill. Own your stuff. You failed to maintain this. You admitted to having knowledge of the conditions prior to my arrearage, and all I'm asking you to do is help me with the electric bill from your negligence, and your response to me was, here, you're evicted. That's retaliatory. There's no disputing that. I should have received some level. I'm okay with moving out of there. I wanted to move out beforehand, which prompted that inspection from the oil company. They knew I was trying to leave because I was unhappy with the conditions of the facility, and they required the inspection before delivering oil.
How many people are living in there now?
Right now, just me and my 2 children. At the time, myself, my 2 children, and my niece. Well, no, not at the time of the deficiency, during the proceedings. So there was 3 occupants, and my children were smaller at that point. There was no heat for multiple winters after 2 winters after they established ownership. They established ownership January 15th. They submitted a radiator bleeding photo and video dated January 21st, 2019, stating that that photo and video supported they bled the radiators in December. So again, they're misrepresenting information to the courts. They're saying, here, Your Honor, here's a photo. We bled it right after we did the conversion to oil, from oil to gas. But that photo is dated from January. In his text message, it clearly states, well, yeah, the boiler was replaced in January. It took under a week. Okay, you bought the house the 15th, you bled the radiators the 21st, so here's evidence that you said I would not be able to come up with that supports the fact that you owned the property during the first heating deficiency, which caused the second heating deficiency, both requiring use of my electricity that you should compensate me partially for. That's all I'm looking for. And I feel like my counterclaim, which the plaintiffs received full judgment on, is an error. Under 14 and 18 of 186, I should have received some level of compensation towards those electric bills. And
What's
that's all
the
I was seeking.
relationship between your monthly rent amount and the amount of contribution towards what you call excessive electricity is there? Like, what's the dollar amount?
What's the dollar amount?
You withheld your entire monthly rent, right?
My entire monthly rent is $960.
That's the amount that you withheld?
Yes, because I had started using electricity in November.
Is it your claim that you paid $960 in excess electricity charges?
No, that was not my claim. I withheld 2 months' rent because there was 2 months during 2019 where I had to withhold where I had to use electricity. I did not know what was fair, and I put it in text messages. I don't know what to charge you. I'm going to the housing court trying to get help. And while I was actively taking those measures and keeping them updated is when they filed against me.
The record in front of us doesn't indicate what you just said.
I filed that, right.
The record in
filed a
front of
motion to
us
expand.
indicates that you were telling the landlord, I'm going to pay just as soon as I get the money. And that you said that for roughly 45 days.
That's correct, because my
You
initial
didn't say
reverse-
anything about concerns about electricity or anything else when you were saying that. You said, look, I'm going to pay, I just need to get the money.
That's correct, because initially I was in the arrears while waiting for my Social Security disability benefits to be reinstated. Upon it being reinstated, I also received my electric bill for November and December, and in the expansion file, motion to file, which you won't allow, it clearly indicates I was using electricity in November, which is why I held 2 months' worth of rent. I didn't know what to charge. I was actively trying to get help to negotiate the bill when they filed against me. The day they became compliant is the day that they served me with a 14-day notice to quit. That's reprisal.
All right, let me see if there are any other questions. No. Thank you very much. Your time is up, and we have your argument.
Good morning, Justices. Attorney Craig Espinola representing the appellees, as you know. May it please the Court. I think we had a breakthrough this morning because I finally heard the appellant admit that the initial arrearage was because of a financial transition that she was facing. But every submission to this court and to the lower court was essentially that she was withholding 2 months' rent. And I want to correct the record. It wasn't $960 per a month times 2, that she was withholding 2 months' rent because of a heating deficiency, which I would submit to this court. The evidence illustrates, the evidence in the record illustrates, was a 10-day period wherein it is true when the oil delivery man came to the house at 4:33 Grove Street in Fall River, where my client lives with her husband, her fiance, her newborn baby, and their 10-year-old son. When that oil person came to the home, he determined that the tank in the basement was no longer a viable tank. And so reasonably,
What was the date of this?
that was in, I believe, late November, early December,
2019.
2019, Your Honor. So at this particular point
So
in
then
time,
it provided some sort of space heater?
correct, but before that,
Is the space heater still in her apartment?
no, Your Honor. Your Honor, we're talking about an isolated 10-day period wherein they decided per the recommendation of the oil delivery man and after consultation with some HVAC specialists, that this was an appropriate time to convert from oil to gas, which is actually essentially would have been a more convenient method for the appellant to receive her heating source. This is an isolated 10-day period in the
She
record.
pays her heat and electricity separate from the rent? She
Correct.
pays her own?
That's correct, Your Honor.
They live in the same home?
They do, and I think, unfortunately, it's part of the problem, because what this court doesn't see, it doesn't see that my client, young mother who is working and at the time was working as a special ed teacher and going to school for occupational therapy, has a newborn child, and the harassment associated with continuing to have an unwelcome person live downstairs.
Well, I think we've indicated that we're bound by the record, so I think you got to stay with the record.
Thank you, Your Honor.
Unless, like I just did, I specifically asked a question asking you to go outside of it. I apologize for that.
No,
You need to stay with the record.
You're right, Your Honor. I appreciate that. And so I appreciate that, because I think that the record is abundantly clear that my client acted reasonably when faced with an unfortunate situation, which was the tank was in need of repair. And I'd like to remind the court, because I'm
Did your
sure
client reduce the rent for that 10-day period?
they did not, because they weren't approached at that point in time by the appellant to say, look, because of the fact that I've got this inconvenience, is there a way that we could work with you? I think there are some text messages in the record. They may not be part of the record, but I think they're part of the motion to expand, wherein my client had indicated, look, we're willing to work with you. But I think what became abundantly clear this morning is this was not a withholding of rent. This was a financial, initial arrears were because of a financial transition that the appellant was going through at that particular point in time. Well, as this court knows, from the record, my clients, this young family, purchased this home in January of 2019. And so they were also a family that, and the record does bear this out, that required, in order to make their mortgage payments, in order to make their bills, in order to support their family, were relying upon the rent from the first floor.
Counsel, I'm sympathetic to your client. I'm sympathetic to the appellant as well. I understand housing situations. But isn't it clearly erroneous for the judge not to find that the appellant was due some reduction in rent, even from your argument, of that 10-day period? I understand there were space heaters, and I understand they wanted to work together. But isn't that the landlord's obligation as opposed to the tenant, that when there is a defect in the property, such as lack of heat, that the tenant is due some reduction?
So, Your Honor, in response, I think, first and foremost, there was not a lack of heat. Let's be clear. The evidence from the record is clear that during that 10-day period, the appellant was provided with extraordinary space heaters that were propane and then electric space heaters, and there was never, not one complaint from the appellant. In fact, the record would bear out that I think she was very happy with what the landlord did. There was no.
And if the electric space heaters resulted in an increase in an electric bill or electric charges to the tenant, you would agree that that excess would be the landlord's responsibility, because the cost of the heat I mean, that's not something that should have been borne by the tenant, correct?
Certainly, Your Honor, I think if there was evidence submitted at the lower court that she had an increase in electricity, but if you recall, I believe the record shows that these were some of these heaters they were battery-powered heaters, and she was allowed to use the basement to charge those particular batteries. So there was no evidence submitted to the lower court that she had an increase in electrical usage from the heaters that she was using.
So you dispute what Ms. Galarza says, that at the trial, there was or she tried to present evidence of notice to your client regarding that the heating was insufficient. You dispute that that's in the record?
Vehemently.
Vehemently.
Correct, Your Honor.
Okay, I just want to make sure I knew what word I was hearing.
Sorry, Your Honor. And I think, you know, I don't want to
I think she would have to have gotten it in through cross-examination, right? Because she didn't testify.
She could have got it in through cross-examination. She could have testified. She could have submitted, you know, bills.
You say she didn't testify, but the judge treats what she had to say in her, I guess it would be like a closing statement, as if it were testimony.
And I don't think it changes the outcome, quite frankly, Your Honor. Anything that she indicated, that the judge determined credibility based on, I believe, in response.
Because I have a hard time treating it as non-testimony when the judge treated it as testimony.
I understand that, Your Honor. I do think, in further response, that one of the reasons that she provides for not submitting any evidence relative to notice to my client, because in response to your query, Justice D'Angelo, about trying to submit evidence relative to notice to my client, she indicates that she lost her phone in the winter of 19 and was unable to acquire any text messages or any notice. And now as she sits here today, and I think this is new, quite frankly, she verbally had some conversation with my client wherein she indicated that she had some difficulties. This is a judgment, Your Honors, that dates back to January of 2021. I know the appellant sits here today and is testifying to this court that she would love to find another place that she wanted to move, but this is 2 years later, and she's still occupying the first floor. The newborn baby that my client had testified with a week after having a newborn baby testified in court is now a toddler. Ms. Galarza has had and has submitted every appeal, has gone to the SJC. The record is clear. It couldn't be clearer from what we've submitted from the evidence. And I would suggest one last thing before I finish, Your Honors, unless you have any other questions, is if we can't believe the written communications that were submitted to the court that the lower court relied upon, then let's look at an independent review by the Board of Health from the City of Fall River, because once it became clear to the appellant that my client was going to move forward with proceeding with an eviction, she contacted the Board of Health in February of 2020, and the Board of Health went to the home, and what did they find? They found that 2 outlets needed to be changed from the older outlets to a GFI-safe outlet, and that the bathtub had some cracks in it, and it needed to be smoothed out. This is the fact that the appellant is here in this court indicating to the court that somehow her premises were not habitable, or that my client somehow breached the covenant of quiet enjoyment, or they retaliated, is a frivolous argument, Your Honors. And I'd ask that you bring justice finally to my clients who have had great expense to follow this appeal and rebut this appeal, and that you uphold the lower court's decision. Thank you.
Thank you. Let me see, no questions. Thank you both. Thank you both for your arguments, and the case is submitted. Next case is 2022 P0643, Adam Silverman versus Shannon Gabriel. We'll likely take our mid-morning recess after the arguments in this case. For those of you who are waiting for later on, we'll probably take about a 15-minute break. All right, Attorneys Sawin. Thank you, sorry for the mispronunciation. I'm just also going to remind you that the case is partially impounded, so not to disclose the impounded information in open court.
Yes, Your Honor. Good morning. My name is Attorney Christopher Sawin, and I represent the appellant, Adam Silverman, on a number of issues before the court. I know that the court is familiar with the documents that both counsel submitted, as well as the facts and the issues that I've raised. So there's really only two topics that I wanted to discuss with the court as far as my oral presentation goes. The first topic is really the difference between a pretrial conference and a status conference. I know that Mother's brief overwhelmingly suggests and argues that the January hearing was in fact a pretrial conference, or at least a continuance of a pretrial conference, but the record is very clear both on the docket, the transcript from the actual October pretrial conference, and the order issued by the court regarding January that it was in fact a status conference. In fact, the record
So I'm struggling with this. I'm looking at the October 19th transcript. The court, this is getting close to her last statement on it. All right, I'll give you a status date in 90 days, and then hopefully you both have the information you're each looking for relative to the finances, and we can enter a judgment as to child support on that date.
Yes, Your Honor.
Why isn't that notice to your client? Were you present?
On the October hearing?
Yeah.
Yes, Your Honor.
Why isn't that notice to both of you that that's her intent, is to enter a judgment in January when you get back?
I would suggest that the element of that the judge's intent to go to judgment in January was preliminarily based on the fact that counsel had all of the financial information, and all that information would be submitted to the court at the January time. Then the court could go to judgment based on all the financial information gathered. There were a number of topics discussed in October which, even come to January, counsel didn't have, such as father's girlfriend's income to make a hypothetical child support for father's second child. That was not.
Why wasn't it provided? Wasn't that exactly what your opponent was asking you to provide?
There was
additional information so that you could go to judgment on child support.
There was discovery that was issued. There was a 26G conference conducted between counsel. At the time, Mother's counsel did subpoena my client's employment records. He works in the union, so he is.
Why did they have to do that, counsel? Why couldn't they just get it from you?
My client was unemployed at the time. He was having difficulty, my understanding, and again, this was about a year ago, from looking at the records, he was having a difficulty getting it from his.
So, but why couldn't you guys have a conversation where the mother's counsel says, I need your financial information so that we can have the right information to decide what child support should be, and not have to subpoena his employer? Did he not have the information? Was that ever communicated to Mother?
I did supply a financial statement during the October pretrial conference, contrary to what Mother's brief says that I didn't. But I actually did. It's on the record during the pretrial that I did email it to Judge Moses's.
Right, but that apparently was insufficient, right? Among other things, she says, I received it this morning and there was no W-2 or pay statement. And so then there's further discussion at which the court certainly seems to think that additional information is needed and gives you 90 days.
Yes, Your Honor. That's because I was retained about 4 days before the pretrial, so I didn't have
And
time.
I understand that concern, counsel, but you
Yes.
had 90 days.
Yes, Your Honor. There were conversations between counsels throughout that time period. The issue is that counsel and I were actually working on a global resolution up until, quite frankly, the Friday afternoon, because that next Monday was the status conference. communication broke down. My intent and plan was to draft up an updated financial statement and have all the information and proposed judgment ready to go for the Monday hearing. But as I mentioned in my documents, I had an illness which prevented me from
Counsel, can
appearing.
I ask you about that?
Sure.
I don't like to give hypotheticals, surprisingly enough, to lawyers, but in this one I will.
Sure.
Let's assume you were present at that hearing. Would the judge's order have been appropriate if you were present just for the failure to comply with the September 30th order and the October 19th order? The judge just said, look, I made an order, you didn't comply with it, here's my order.
I wasn't available for the September hearing. I was retained in October.
Okay, but the judge, just because you came into the case late, that doesn't mean that all the judge's prior orders, you just go, forget about it, I wasn't part of the case. The judge made an order in September 30th. It wasn't complied with. The judge made a further order on October 19th. It wasn't complied with. So at that, whatever you want to call it, status conference, pretrial conference, the judge says, again, hypothetically, you're there, says, look, you didn't comply with these two prior orders, period. Here's my order. Would that have been appropriate if the judge had done that?
I think that under what the judge's language from the October hearing, because I was there, it was my understanding that as long as counsel had all of the financial information and that financial information was given to the court, then the court could have gone to judgment, and that would have been fine.
But you didn't. I understand you were sick.
Then-
But on the hearing date, you hadn't complied with the order.
Correct, because I was ill. And there's nothing that the judge said that said, if you don't comply with the order, then I can go to judgment.
I think that's what your argument reduces to. That's the bottom line.
Correct.
Is that you're saying that when a judge says you must do something within 90 days, and I'll see you on the 90th day in order to enter a particular kind of order, such as a child support order, the judge is also required to say that if you don't comply with my order, I'm going to do X, Y, Z. So what's your best case for that proposition?
The best case that I have for that, Your Honor, is going to be the Wilkins v. Cooper case. The facts are strangely similar in that the attorney in that case actually stopped practicing law, didn't give the notice of the status conference to the client, so no one showed up, and the judge went to judgment on that, and that this court actually reversed that, saying that there wasn't proper notice of that hearing, but even if there were proper notice of the status conference given and everyone showed up, the judge should not have gone to judgment because there was no notice the judge was going to judgment on that day. And I find that
The judge is faced with a circumstance that there needs to be a child support order of some sort, and the entry of a child support order has been deferred on at least 2 occasions because there hasn't been sufficient financial disclosure made, at least by your client and maybe also by the wife. At some point, the judge has to take the interests of the child into account. And when it comes to the 3rd date and you don't appear, you don't file a motion seeking to continue, you don't file even a document that says notice of unavailability due to unexpected illness, and neither you nor your client has provided the information that the judge ordered, where do we get an abuse of discretion in entering a support order? This is not a sanction. It wasn't a dismissal of the case. It was an order of child support.
the issue that I have with this is that it went to judgment. The judge could have easily issued a temporary order, which would have allowed everyone more time to come back and have an actual 2-party hearing
So
on the
that's the
merits.
error, that's the response to Judge D'Angelo's question, is that if this had been a temporary support order, it would have been okay, but because it was a final child support order, it wasn't?
Yes, because it was
Okay.
done ex parte.
What's your case for that?
Again, I mentioned some cases in my brief, but I'm again relying on the Wilkins case that I just mentioned, that the judge should not have been allowed, or should not rather, have gone to judgment because I didn't have notice that failure for me to appear or failure for certain information to be given would allow the judge to go to judgment. I mean, in the October hearing, it was my understanding that as long as counsel had all the financial
Where would the constraint come on the judge's authority to enter a support order in these circumstances? If you had notice, if we find that you had sufficient notice, then is the judge precluded from entering the order that she did?
No, I think that if long as
Okay. I think then I understand your argument. So the success of your argument depends upon whether or not you were on sufficient notice that the judge might enter a support order at the next hearing.
I believe that my issue is that proper notice wasn't given that the case would go to judgment unequivocally.
Do you have a defense on the merits to what was actually ordered? I mean, one of the question that's being asked, all right, that, 10,000 feet, this is a dispute between lawyers about what one lawyer said to another. It's not the kind of thing we see on a regular basis in here, and frankly, don't want to see. We want to see you guys get along, figure it out, and not bring this kind of problem in. But one of the questions that Judge D'Angelo is asking you is, how were you prejudiced? I mean, there was going to have to be some sort of child support order entered, and he owed it going backwards. So do you have a defense on the merits at all?
Well,
to what was entered?
I don't know what the true child support amount would have been, and my only really relief...
Have you moved to modify the child support?
No, Your Honor, because this is on appeal. I did submit a motion to stay the judgment pending the appeal, and there was a...
But have you filed, for example, a complaint for modification?
No, Your Honor.
Can do while the case is on appeal.
Anytime.
Yes, Your Honor, I just haven't been retained for that. There was a complaint for contempt that was subsequently filed after the judgment entered, which, again, my client was found in contempt of because of the child support issue. But the problem is that if I had filed a complaint for modification, the court wouldn't have been able to go backward. The court can only go forward from the date of service of the subsequent modification. And the issue I have...
Right, which is why you should do it right away.
I don't dispute that. I just wasn't retained on that particular topic.
Yeah, I get it.
But it wouldn't have been able to fix what the court had already entered into judgment, which is what the issue I have is. And had, quite frankly, a two-party hearing been issued and the judge still came out with the same number and the same thing that the court issued, that would have been fine. I just wanted a two-party hearing on the merits. That's all I was looking for.
And I'm asking
the
whether
issue I
it made a
have.
difference. And the fact that we don't know whether it made a difference is also troubling to me at 10,000 feet. You said earlier something that I didn't see in any of the briefs. And that is that you had been talking to opposing counsel right up to the Friday night before the Monday hearing in January?
Yes, Your Honor.
These were phone calls directly with Ms. Bielowitz, or whatever her name is?
Attorney Bia Longcheck. Yes,
Bia
Your Honor.
Longcheck.
At that time, her and I actually had a fairly cordial relationship, in my opinion.
Any more questions? Do you have any questions? Do you have any questions? I don't see any other questions. Do you have anything you want to add?
The only thing I was going to add, Your Honor, is just on Mother's brief on page 18. I know that Mother is heavily relying on a quote from the judge. However, that particular quote completely omits a really crucial part of what the judge actually said, which is referenced on Record Appendix number 43, where the judge made the comment that as long, I'm paraphrasing that, as long as all the financial information, everyone has it, then the idea is that we can go to judgment in January. And I find that troubling that that particular part is omitted, so Mother's really relying on the first third and the last third of the sentence and not the middle third. But with that, I know the court is well aware of my position, and I certainly appreciate Your Honor's time.
Thank you.
Thank you very much. Thank you for your argument.
Thank you.
Good morning, members of the panel. I am Brad Greenberg, and I represent the appellee, Ms. Shannon Gabriel. I'm going to try to not get involved in the interpersonal relationships involved in this case between counsels.
Well, I don't think we want to get into the interpersonal relationships, but there sure as heck is a question about who said what to whom on that particular date, right?
I think I can answer your question fairly succinctly. This was the hearing on January 31st, 2022, was a Zoom conference. It is understandable that sometimes attorneys can fall ill. It's happened to me. I'm sure it's happened to everybody in this room.
Attorneys can what? I missed what you said.
That an attorney can fall ill on the eve of a hearing. But as the old adage goes, where there's smoke, there's fire. And here's what the smoke and fire are. Normally, if an attorney falls ill, they're fortunate to have an associate, in this case, Attorney Morin. And it's a Zoom conference, which means you get on the computer, put in the number, and you're in less than a minute. What would be expected to have occurred would be that Attorney Morin would have gotten on the Zoom, said to Judge Moses, "I'm sorry, Attorney Sawin is ill today. I don't know much about the case. He fell ill last night, this morning, whatever. We'd like a continuance." Then, of course, then counsel for the appellee would either assent or argue to the contrary. That didn't happen. Oddly enough, counsel for the appellant had Attorney Morin call opposing counsel and not the court. And then some conversation
That would be
occurred.
what the rules would expect. Right? Before you call the court and say, I want a continuance, you call opposing counsel to see whether they agree or not.
It depends on the circumstances, but normally,
Actually, unless there's simply no time, I don't think it does depend on the
well,
circumstances.
it's a Zoom conference, so there's always time.
No, counsel, the rules are, as I understand them, that if you're going to make a motion to the court, you're supposed to address it with opposing counsel first to find out whether opposing counsel agrees or not.
Unless there's an emergency.
Right.
Because the odd thing really is
But it's a
that
Monday morning with a 9 o'clock hearing, so this call was made at 8:40, right?
even if Attorney Morin had called opposing
Is
counsel.
it true that the lawyers were talking right up until Friday night?
I have no idea. It's not on the
Okay,
record.
do you
It's the first time I'm
practice
hearing
with,
about that.
do you practice with attorney, and I don't want to even try her name again because I wasn't close.
No, I don't.
You don't?
I've never,
Okay.
I've spoke to her once in my life on the
So
telephone.
you're a successor counsel?
Yes. She did not want to participate in this appeal, so the appellee found completely different counsel in that regard.
Counsel, I am very troubled by what happened. I don't care whether it's a Zoom hearing or an in-person hearing. It's a hearing. Opposing counsel calls a lawyer that morning and says, "I'm sick, I can't attend. Basically, will you let the court know?" Lawyer, I don't know whether it's yes, no, or otherwise, but the lawyer's asked by the judge, "Do you know where the lawyer is?" "Yeah, he's sick." And the judge still goes forward with the hearing. Why isn't that an abuse of discretion? You've just turned a litigant who's represented by counsel into a pro se litigant where orders are going to be entered into. Why isn't that an abuse of discretion on the judge?
Let's go back to the smoke and fire argument. The thing is that just previous to all this, October 19th, 2021, the court unequivocally said, you need to produce these documents.
You know what's
Counsel,
also
how much
clear to
time do you
me?
need?
You know what's also clear to me from that hearing? There was financial information that was required by both sides.
She
from both
provided
sides.
it.
And so when Ms. Bialachik says to the court, I understand if you're sick, and things happen and things come up. But I do just want to say, too, that, you know, this has been continued because the defendant hasn't produced financial documents, and we weren't able to enter a judgment, and it just feels a little planned, and that we didn't, again, we're supposed to enter a judgment today, thus suggesting to the judge that there's something trumped up about the illness, and also inaccurately stating to the judge that the only previous problem was a failure to produce documents by one side as opposed to failure to produce documents on both sides. It seems to me that something, let's just say, unflattering, counsel is conducting herself in a way that we wouldn't really recommend.
I can address that. If you go forward in that transcript, as it turns out, Attorney Bolanczyk, I think is how it's pronounced.
How do you say it?
I pronounce it Bolanczyk.
Bolanczyk.
Bilonczzyk. I hope I got it right. Anyway, the truth of the matter is that when the order was issued, and remember, Judge Moses she said it twice during that October 19th hearing. The fact that she used the term hopefully was a term of courtesy, because when she first said, I intend, she said, I intend to enter a judgment.
I'm not worried about what was said on that hearing. I'm worried about what Attorney Bolanczyk, said to the judge during the January 31st.
Two important things. Attorney Bolanczyk, from what I understand from the record, is vehement that she never assented or stated that she would assent to
That's
it.
also not my point.
Okay, maybe I misunderstood you.
My point is, she does not accurately disclose to the judge that there was information missing from both sides. Instead, she suggests to the judge that there was only a failure to produce documents or information from one side, and that the illness is convenient rather than true. And I don't know that there's any factual basis for that.
If you go forward in the very same transcript.
The next thing she does is she asks for
Venmo, which is how she was getting paid as a nanny, and all the other, and I think she actually says, I have the records, I've done what you asked me to do, and that this is what the issue was.
Had
It
she
wasn't a
submitted
matter
that
of-
to the court?
Excuse me?
Had she submitted that to the court?
I think she did, and I believe she did from looking at the record.
On that
I wasn't
day.
there.
On that day, correct? The day of the hearing, that's when it was submitted, which is exactly what counsel said he was going to do at that time, but he was sick, right?
Well, the truth of the matter really is I don't know what.
She says, I believe I did file that, but judge doesn't think that it's been filed. And so then Ms. Bolanczyk says, should I email it? And the judge says, you can, at the conclusion of the hearing.
Okay, well, I suppose then she did come prepared. I can't.
That's not coming prepared in any way associated with what the case was litigated out in the briefs. The entire argument that was being made was that the father should be penalized because he had not provided information prior to the hearing on that Monday. And to say she came prepared because she showed up with something that day at an ex parte hearing, that's just not consistent with everything I just read in your briefs.
Well, the odd thing about this is that, again, even if, and it does happen where one attorney will call another, it's very common, would you assent to a continuance for X, Y, it's very common. I've done it maybe 1,000 times. But the difference is when you have to be in court, and it's that day, you may call the other lawyer, if you can even get them, and say, tell them. But what you always do is either you call the clerk
Okay, so
of court
I want
and
to
say, "Bring a
focus
note
on
up."
that. I want to focus on that because I don't disagree with the fact that a mistake was made here by father's counsel. they should have gotten on the call. They should have contacted the court. It's very clear that the court was upset, that the court itself had not been contacted, and that should have happened. But we have an affidavit from someone who's been practicing law for about a year that says, here's the conversation we had. I said to Ms. Bialowitz, I missed the name again, I'm sure, do I need to file a motion to continue? And she said to me, don't bother, I'll take care of informing the court. That's in an affidavit signed under oath. There is no response under oath to that at all.
I thought that Attorney Balanzik did say I never told.
She does, in a pleading.
I think it's in the opposition to
Right,
the.
it's in the opposition. It's not signed affidavit, it's not under oath, and she, to the extent she contradicts what I just said, it's not even clear to me that she does.
Well, the interesting fact about that as well is that, again, I'm kind of an old timer.
Would you agree with me on this hypothetical question? Let's assume that she's telling the truth. Let's assume that affidavit is accurate. Do you think that this judgment should stand in the face of a 60B motion that was filed literally the day after it came out?
Applying the law, yes. And the
Yes?
reason why is because the appellant has failed to demonstrate a meritorious claim or defense, or like the court.
Well, wait a second. No. If the judgment was obtained by fraud or mistake,
You still have to demonstrate that there would have been a different outcome, a meritorious claim or defense.
I'm not certain of that.
What's your best case for that proposition?
Well,
I'm looking for a case site.
oh, sure. It's the Amaral case. And I think it's in the Ryan case as well.
And they say that you need to demonstrate a meritorious claim or defense in order
Yes,
to
I'll
obtain
give
a
you right
Rule
now.
60B relief?
1 second.
If it was obtained by fraud or mistake?
Yes, Ryan v. Everett.
Okay, take a look at that. Thank you,
78 Mass
counsel.
App 340, 2010.
Let's assume for a second that we agree that counsel should have done more to get the continuance by calling the court, that his conduct was inappropriate for not doing that. How do we go from there to the court prejudicing the defendant because of counsel's inappropriate conduct?
Well,
Shouldn't the judge have just said, look, I might have a motion for, you might have a motion for contempt, or I might have a hearing about contempt for that lawyer, but we need to schedule a further hearing before I enter orders against this person who's now pro se, who says virtually nothing at this hearing in his.
there was nobody there from
Yeah,
the
there's no
appellant.
process.
just to
Even
be clear.
worse, ex parte. So now it's a totally ex parte proceeding, entering a judgment against a party.
But again, when you start with the fact that they never contacted the court when normally you would, and had someone contacted the court, when you read Judge Moses's denial of the Rule 60, she comments, never contacted the court. It appears that the court wasn't contacted by anybody from counsel for the appellant's office because the question might have come up, where are your documents? So instead, there was a call to opposing counsel because that question won't come up and can't be enforced, like Judge Moses, in fact, did. Judge Moses
One of
was
the
clear.
things that I'm looking for is, I don't, and I may have missed it in the record, were the text messages, are the text messages in the record that we've got, the record appendix?
There were no text messages between Counsel Balanzek and anybody from the appellant's side. And that's another issue that I wanted to bring up. Normally, when it's, you send you send a thank you text, thank you for agreeing to the continuance. You fax it. You do something to evidence that should something go wrong, like we have here, because no one really knows what happened during that conversation. We have two different points of view, and no one's.
One with an affidavit signed by an officer of the court that says it's true.
I wasn't there, so yes, those are the
Correct.
facts that you're relaying to me. Yes, they are the facts that and Attorney Balanzik says otherwise. But normally, thank you for your courtesy today. Let me know what happens. How about, I'm available on these dates. There was nothing more than this affidavit, and there's nothing else, and that is abnormal.
Absolutely right. There's
So-
no question. There's no question it should have been handled differently. And there's no question that there are concerns, legitimate concerns about the fact the judge said 90 days earlier, look, you need to provide some documents so we can go to judgment, and no documents have been provided as of that date. That's all true. But if someone says, hey, you're going to take care of this for me, and you say to them, you know what, don't bother filing something, I'll take care of it. That's between counsel, and that's got to be handled properly.
I would agree, but again, I wasn't there, and I believe in comedy between, there's no attorney who's going to stand before you and say anything but, hopefully. The truth of the matter really is that we have a dispute, and Judge Moses pointed that out.
Well, we have your argument. Let me see if there are any further questions. No. All right. Thank you both for your arguments. In this case, I'll also say thank you both for your professionalism here. It's important to us all in every case.
Agreed.
And with that, the case is submitted.
Thank you for your courtesy. Have a good day.
Welcome back. The next case is 2021 P1029, BIPIN PATEL, again, I apologize for mispronunciations, versus Cambridge Licensing Commission. I hope at least I got that part of the side of the V pronounced correctly. And is it Attorney Nolet?
Yes, Your Honor.
Great. We're ready whenever you are.
All right. Members of the panel, may it please the court. My name is James Nolet. I represent the appellants Deru and Bipin Patel in the present proceeding. I'd like to begin by briefly addressing the factual underpinnings of this case, because the context here is important. Deru Patel, appellant Deru Patel, spent years working as a civil engineer before saving up enough money to buy his liquor shop in August of 2005. Over the next 5 years, he worked around the clock to expand the business and eventually managed to double its revenues. At that point, it's my understanding that my client's landlord began pressuring him to sell the business to him.
Is this in the record?
I'm not entirely certain as far as this particular section.
Right,
This
so
may
you
be
know that
outside.
we can only consider matters that were, that are in the record here and were before the
Yes,
judge below.
I'm just trying to clarify, you know, there's a lot of discussion in the record of alleged malfeasance by my client, that a lot of that arises from sort of targeted harassment from his landlord. I just wanted to sort of clarify that before sort of proceeding with the issues that are in the record here. So in this case, what we have is a bargained for exchange with mutual consideration. The CLC.
Which is where, and I'm sorry, I'm going to jump in, but you have a claim for breach of contract, and it took me halfway through the second brief before I asked the question, what's the contract? Where is it?
So it was partly. I would say that this particular provision was an oral contract because it wasn't fully integrated into the order of the.
You're going to you're going to sue a municipal body based on an oral agreement.
So what happened, Your Honor, was that my client was prosecuting.
Have you thought about the limits on that? Because there are statutes about who can bind a municipality in a contract. And I'm pretty sure if I look, I'm going to find that an oral agreement with a municipality wouldn't be enforceable.
Well, it is in the record of the hearing. I believe I included within the record is the transcript for that hearing.
That would be helpful. Can you tell me the page number of the contract on which you are suing?
Yes, let me see here.
The record appendix. Where in the record appendix will we find the contract? And then we're going to turn to that page.
Let's see. Apologies, Your Honor, I don't have the table of contents for the actual record appendix here.
What did it look like? Does it say contract, for example,
No,
or
it's,
agreement
it
at the
reflects
top?
The oral agreement insofar as it's the transcript of the hearing where they reached it. So essentially, the attorney representing my client at the time.
Is that how it's alleged in the complaint? That the contract is an oral agreement based on statements made at a hearing?
So it was partly reduced to writing. The only thing that wasn't in the actual writing was my client's agreement to not to pursue his pending appeal at the time.
Did he have a, sorry.
Was the writing, does the writing Does the part that was reduced to writing look like a contract?
It
What does
looks-
it look like?
So it looks like an administrative order under the
Okay,
relevant
so that's what
statute.
you're relying on for the contract. So let's look at that. Which page is that one on?
46. You're talking about the order of October 9th, 2012?
Yeah, here we are. So as far as that goes, I don't have the specific text of the order in front of me.
Well, no, but I'm asking you a question. I wasn't clear. Are you relying on the order of October 9th, 2012?
That order reflects the agreement, but not the entirety of the agreement, because it doesn't integrate the...
What's missing is a representation to the effect that he meaning your client, will dismiss a pending appeal?
Yes, and that, I would note, is outside of the scope of permissible orders of the CLC under the relevant statute. And so it's...
I don't know what you mean by that.
Let me find...
What's outside, what is that is outside the scope?
So the Licensure Commission didn't have the power to order him to stop prosecuting his appeal. Therefore, they went outside the scope of what would be exclusively an order in this case.
You're saying that if we read the transcript that's in the record, there's an order to stop prosecuting an appeal?
No, so there isn't. So that's why I'm saying that it wasn't fully integrated into the order there. It was outside the scope of what the commission could have done.
But I'm not understanding, what are we going to find in the record with respect to this agreement that we don't have in the October 9th, 2012 order of the Cambridge Licensing Commission?
And so that would be the agreement to stop prosecuting the appeal.
And so your client in this hearing on October 9th, I believe it actually occurs on the 9th, agrees to stop prosecuting a pending appeal?
Yes, of the original decision to revoke his liquor license.
So there's a document later on, I think it's the March order, which indicates that your client had stopped prosecuting that appeal before October 9th.
I'm not familiar with that. The transcript of the hearing shows them discussing it at that hearing, Your Honor. I'm not sure about the
And is
document you're
there,
referencing.
and your view is when I read that transcript, which I don't recall it being quoted in the briefs, I'm going to come away from the reading of the transcript with the view that there was an explicit condition from the CLC saying, we will agree to this October 9th extension, 90 days or whatever it was, to try and find a buyer, if you agree to dismiss your pending appeal?
Yes.
And what exactly did they say?
I believe it was in fairly informal language, but my recollection was that it was, my client's former attorney said, they floated the idea of dismissing the appeal as a condition of allowing him additional time to line up a new, applicant for the transfer of the license.
And that's what you put in the complaint on Record Appendix page 40, correct? Paragraph 10, the commission's order also provided that the revocation would be suspended for 90 days to give Patel an opportunity to avoid revocation by selling the business.
That's correct. And so in...
So that's all in the October 9th, 2012 order. And then there's a March 25th, 2013. I don't know if these are called orders or decisions or what, where the license is again revoked based on subsequent violations. And the appeal from the March 25th order, March 25, 2013 appeal, is withdrawn, and that revocation is final. So even if we were to conclude that there was a, quote, contract, that the complaint states a claim for breach of contract, what would you get, given that the license was revoked subsequently and that revocation is final?
So, Your Honor, I would say that, expectation damages, the traditional common law contract damages would be available, or possibly specific performance as far as ordering the commission to either
What would it be? There was never a willing buyer.
So
There was never a qualified buyer.
There actually was, Your Honor. So my client produced his brother, Dhiru Patel, as a qualified buyer in November of 2012.
Who withdrew. The commission did not do anything to make him withdraw. He just withdrew.
So the commission, Miss Elizabeth Lint, the executive officer of the Cambridge Licensing Commission, specifically told BIPIN Patel's attorney at the time that they would not grant the license transfer to him or to any other family member.
So the problem with this argument is, this does strike me as collateral estoppel. You literally have a decision which holds that, which finds that he withdrew, and that there was no evidence of a rule like you're stating. So we have a finding that it was withdrawn voluntarily, and that went to judgment, and the appeal periods have been exhausted. Why isn't that collateral estoppel?
Because, Your Honor, they didn't really analyze BIPIN Patel's claim there. I mean, he had it on good authority from the executive officer of the Cambridge Licensing Commission. He was a ready and able buyer.
It was they who didn't analyze it. I mean, they find that it was withdrawn.
It was withdrawn based upon their own inducement, based upon their representations that they wouldn't approve it.
That's what you say now.
And the records replete with the CLC and the ABCC acknowledging that BIPIN being related to Dhiru was no impediment. And yet here is the executive officer of the Licensing Commission telling them that, no, we won't be considered. And I would say that the breach here is really that my clients were entitled to have BIPIN's application evaluated, and in accordance with the intentions of the statute, that there be an open hearing as opposed to this sort of backdoor situation that happened.
And that may have been a good grounds for appeal of that decision. This is not an appeal of that. This is an appeal of a breach of contract action, and going back to my colleague's question, even if we find there's a breach, you still haven't even remotely persuaded me that there's an appropriate remedy.
I would say the appropriate remedy here is for the Licensure Commission to proceed with what they should have done in the first instance, which is a public hearing on the merits of BIPIN's license application, which he was entitled to, and both as a due process matter and as or an administrative process matter, and as a matter of the sort of informal agreement that we're dealing with here, that they would consider qualified buyers. Do
you think it makes any sense from our perspective? And I mean, maybe it's unfair to ask the question that way. Do you have any case law that suggests that an informal settlement agreement with a municipality, that the elements of that agreement are enforceable in a breach of contract action?
Let me see here.
I mean, you have the Rule 23 that says that such an agreement might be void as a matter of public policy. But do you have any that say that that it could be enforceable?
So I would say that those same precedents, as far as the district convenience and the Beacon Hill Civic Association case, they enumerate this public policy.
Yeah,
that-
don't go there. Answer my question,
Yes.
which is, do you have any that say that it is enforceable? An informal settlement agreement or an oral settlement agreement with a municipality is enforceable?
So I do produce several cases where it discusses where, where the Commonwealth contracts with a party. It's, here, let me find it.
Sure. Contracts are enforceable. They have specific rules around them because, you know what? Municipalities have to buy things, and so that has to be enforceable. But there are rules about who has to sign those things and how they get signed and who has the authority. The notion of an informal agreement with the municipality, I think, is a long way from those cases.
I mean, I would say that the CLC has the power to make agreements revolving around licensure decisions such as this. I mean, let me think. I mean, so as far as the intent on declaring such agreements void, it's the public policy analysis, and the public policy for this statute is.
I think we're going to have to
open.
leave it there because your time has expired.
My apologies, Your Honor.
Let me see if there are any further questions. No, thank you very much for your
Thank you.
argument. Is it Attorney Klimola?
Klimola.
Klimola, sorry.
Good morning, Your Honors. May it please the Court, Attorney Kate Klimola, on behalf of the defendant appellee, Cambridge Board of License Commissioners, which is named in the suit as the Cambridge Licensing Commission. We are here today because the Cambridge Board of License Commissioners issued an administrative order. This order was no different than the many administrative orders that are issued throughout the Commonwealth on a daily basis. The plaintiff's argument that this administrative order was an enforceable contract is simply misplaced. Now, the issues before this court today are whether the trial court correctly ruled that the plaintiff's claims were barred by res judicata, both
Can
claim
we start
preclusion-
here? If and when, let's not say if, when I go to the transcript that your opponent has cited, and I read in that transcript, we'll agree to extend 90 days while you try to find a buyer, but you need to dismiss the appeal. Could that be binding on the Cambridge Licensing Commission? Is that a contractual agreement?
Well, I would start with first, you won't be able to read that transcript because that transcript is not in the record. What you have before you are the October 9th of 2021 order and the subsequent March of 2022 order. The March of 2022 order lays out the procedural history and the agreements that the parties had come to.
It does, but you're telling me there's no transcript of the October 9th hearing?
I'm saying that if a transcript was made, it has not been entered into the record.
So on the March 25th, 2013
I
order-
apologize, I misstated the year.
Yeah. I'm looking at the first page of that, which is Record Appendix 49. The bottom, it says, on September 18th, 2012, an agreement regarding the license suspension was negotiated by your attorney, and this is to the plaintiff, and Elizabeth Lint, Executive Director, to reduce the number of days of the alcohol license suspension to 14. You withdrew your appeal from the ABCC. That looks to me like it could be construed as an agreement of some sort.
And that's the suspension that was imposed. That agreement only concerned the length of suspension for a prior violation that had happened before.
So that doesn't relate to the October 19th suspension?
The October 9th order.
Sorry, 9th.
Yes, the October 9th order imposed that suspension that was agreed to be reduced.
Oh, wait a second, now I'm lost.
Confuses me because
Yeah.
the October 9th suspension was a 90-day suspension.
Yeah, where does 14 days doesn't
So
even,
reduced is to 14, it seems totally backwards. Why would someone withdraw their appeal for a reduced amount of suspension? The suspension was,
are you sure that what they're referring to in the March 25th, the withdrawal of the appeal even relates to October 9th? Because the way I read it, that all happened on September 18th.
Oh, true.
And I think that after that, on September 26th and September 27th, a investigator for the Cambridge Licensing Commission went to the establishment and determined that it was being operated in earlier than 11 a.m., and that's what caused you to come back on the 9th. Am I misunderstanding the record?
No, you are correct. I had misread it
So
this
the
morning.
way I read this was the withdrawal of the appeal was related to something that happened on September 18th, not even on October 9th.
You're correct. Yes.
and so was there any agreement but after October 9th with respect to, well, I guess I'll just say that. Was there any negotiated agreement of any sort?
There was not. In fact, if you read the October 9th letter, the last line is that you have the right to appeal this decision to the ABCC. If the plaintiff in
Which
this
I take
case-
it as another way of saying, in response to Judge Wolohojian's question, there was no pending appeal as of October 9th.
Not regarding the violations, not regarding the October 9th order.
Well, there couldn't be, because the order didn't come out till October 9th.
Correct.
Your opponent says, this deal was, I'm going to withdraw the appeal, and in return, I get what's in the October 9th order, 90 more days to try to sell my business, or sell my license. What was the pending appeal? Looks like to me like it was gone already. And you say the record, pardon me for being a little frustrated, but I don't see a transcript from which I can determine that. The only indication in the record is that there was no pending appeal that could have been consideration as of October 9th.
I agree.
Well, this is before us on an appeal of a motion to dismiss. And in a motion to dismiss, and I just quickly looked at I believe it was Judge Pasquale's order, recognizes that he accepts the facts in the complaint as true for purposes of the motion. And going back to what I read opposing counsel on page 8 of the appendix, paragraph 10 basically says there was an agreement between the commission and Mr. Patel that he would have 90 days to find a buyer. And the allegation in the complaint is that was reneged upon by the commission. So how does Judge Pasquale reach the decision? And again, I might agree with you that might not be a great contract, but maybe an oral contract. How do we get to the fact that that's not enough?
The plaintiff may have agreed with the licensing commission's order, but that does not make it a contract. This was not a bargained upon, negotiated, with consideration agreement.
I'm with you on that, but where is the evidence or facts that Judge Pasquale can rely on to make the finding that you just made, as opposed to the allegations in the complaint that Mr. Patel made?
Sure, and he could rely on, and correctly did, the October 9th, 2012 order itself. That was heavily relied on in the complaint by the plaintiff in order to say that there was a contract. The board provided the order itself in its motion to dismiss and then its motion for reconsideration.
Let me ask the question that Judge D'Angelo is getting at slightly differently. Let's assume that the record is we have the order of the CLC from October 9th. We don't have a transcript, as your opponent says, which will tell us that there was some agreement in return to withdraw an appeal. But it's alleged in the complaint, let's just assume that it's alleged in the complaint that there was a contract. Are we able to decide as a matter of law that there wasn't, based on the record that we have in front of us?
I don't think the court would have to reach that question in order to decide this case.
Well, why don't we answer my question, because I like my question.
Yes, you would be able to decide as a matter of law that there is
And
no
how would we do that? We would say we have the order. What else would we say?
Because the case law states, and I'm referring to All Season Services versus the Commissioner of Health and Hospitals of Boston, an SJC case at 416 Mass 269, a 1993 case, that a contract with a municipality has to be expressed. There can be no implied contract. At best, what the complaint alleges is this implied.
That's not what the complaint says, counsel. There's nothing implied about it in the complaint. The commissions gave the opportunity to avoid revocation by selling the business and gave them 90 days to do that. Then further down, it says that didn't happen. That's not implied. That is the plaintiff alleging this is what the commission said. In reliance on what the commission said, I did X, and they didn't fulfill their part of the bargain. There's nothing implied about that. That's pretty expressed to me in the complaint.
And I would suggest that in the complaint, where the complaint is talking about the consideration, that is not express. That is an implied contract. What you're reading, what the complaint does, is reiterate what the administrative order is from October 9th, that they would give him until January 15th of 2013 to find a suitable buyer. And we haven't gotten to this yet, but he didn't find a suitable buyer by January 15th of 2013, that he would also abide by other conditions. And when he couldn't find the suitable buyer by January 15th of 2013, the commission was generous enough to give him even more time until he violated the other conditions of that same order, which were to not open before 11 o'clock in the morning. He violated those conditions on 2 dates. And then in March, the licensing commission had enough and held a hearing to revoke the license.
Let's say we accept the fact that there was a contract. I'm not saying we will, but an oral contract, and the commission didn't fulfill its part of the bargain. Counsel says there is a remedy somehow at, I guess, common law. Do you think there's any remedy? Because after that oral contract may have been violated, there were other problems. So is there a remedy even if we rule against you on the contract?
As I heard counsel stating, the remedy was to give Mr. BIPIN Patel a hearing. He voluntarily withdrew his application. There is no remedy. If the remedy is to give him a hearing, the commission would have given him a hearing if he had remained.
Are we talking here about, there are two plaintiffs with the same last name, so are we talking here about a remedy for Bipel?
BIPIN Patel was
Bipin?
the proposed
Buyer.
or alleged buyer. Yes.
Okay. So that would be the possible relief for him?
Correct. As I understand plaintiff's
But
argument.
what relief could be obtained from that if the license has been revoked and not appealed?
That's not clear to me.
Yeah.
I would also point out, even if this court were to find that this administrative order is a contract, this is not an enforceable contract. And I would point to this court's own decision in District Convenience versus the Board of Selectmen in Dedham, which is an unpublished
Do you think
case.
that the Cambridge Licensing Commission has the authority to enter into settlement agreements so that it can resolve litigation short of having to go to a final order? How about the Cambridge Zoning Board? Do they have the authority to enter into a settlement agreement?
Into a settlement agreement in order to settle the issue that's directly before them?
Yeah.
Yes, I would suggest that's what happened in that September case.
Okay, so why can't they settle a case? Why can't we have an enforceable settlement agreement? Because it seems to me you're arguing that they can't settle the case
So
in the context of a license, an alcoholic beverage license.
Sure. I think there's a difference between what the Licensing Commission did in settling the case to reduce a suspension from a longer suspension to a reduced suspension versus not revoking a license. And that's when I know the court didn't want to talk about the public policy issue when the plaintiff was arguing, but I think that's when we get into the district convenience case and the Beacon Hill Association case.
Just to be clear, it's not that I don't want to talk about it, it's that I wanted to ask you this question. I mean, I'm very troubled by the notion that we're going to write law that hamstrings the ability to settle litigation with municipal bodies short of going to judgment.
And I don't think that's what we're suggesting. I think it is perfectly acceptable for the licensing commission to come to an agreement that they will reduce a suspension from one term to a shorter term in exchange for withdrawing an appeal. I think it is something else to suggest that the licensing commission created a binding contract and then breached that contract when it revoked a license, when it is clear from Chapter 138 that all the licensing commission should be considering when deciding if a license should be revoked is the public good.
So I understand that argument, and thank you, that's very helpful to me. Is the problem is it a temporal problem? I mean, what concerns you and what you just said, it seems to me, is, look, we can't agree not to revoke somebody's license in perpetuity or even for an extended period of time, because it's our job to make sure that they're doing what the public needs them to do, right?
Correct.
So there has to be some limits on what kind of settlement agreements can be entered into by a municipality in these contexts. But there also are some availabilities to settle.
And I think that's when we would look at that Beacon Hill Civic Association case.
Okay, thank you.
I see my time is up, so if there are no further questions.
I don't see any. Thank you very much.
Thank you.
Thank you.
Thank you both for your argument, which has been helpful, and the case is submitted. The next case is 2022 P0353, Robert Leaf versus Michael Driscoll. Mr. Driscoll, we're ready for you whenever you're ready.
Pardon me. Good morning, may it please the court. My name is Michael Driscoll, and I'm here on behalf of myself. This case is about the right of access to courts and the limits of courts to entertain litigants' intentional corruption of the judicial process by willful and intentional fraud. For two reasons, I asked the court to find in favor of me, the appellants. First, because the standards of intervention, which are easily met, have been persuasively satisfied here, and because the lower court lacked the degree of judicial discretion to make its determination. So this case is very straightforward. There's no heavy lifting. It's intervention. It's plausibility.
Mr. Driscoll, I'm
Yes, sir.
going to interrupt you. I'm confused as to why you think you need to intervene in the case when you're already involved in the case as a party. Could you clarify that for me, because I'm missing it?
Yes, sir. So there's a distinction in procedure between being within a case versus being a party to counts in a case, which the judge, I'll cite you to the transcript. The judge specifically makes this distinction. While early in the transcript he says, quote, "Mr. Driscoll, you are fully a party to this case. You can do everything anybody else can." Later in the hearing, because it was a combined hearing, he specifically says, "You don't have standing to challenge counts 1 and 2 because you're not a party." But that's the entire point of the intervention. So while I may have been within the same docket number, I did not have standing to challenge Mr. Lee's claims against James Driscoll, which I assert affect my rights. So I disagree. The case law is very clear, distinguishes the difference between I mean, being in a case is just an administrative convenience. You're either a party who has standing to
You may be a party and not have standing to assert certain things. That doesn't mean you can intervene. Because intervention brings you into a case where you're not already a party. Do you have a case where holding that you can use, is it Rule 24? To intervene into a case where you're already a party?
I believe I cited that somewhere in my reply brief. At the moment, I would have to just rely on what is in my belief for that. But it is my contention that my standing as a plaintiff in counterclaim or plaintiff in cross-claim, that is not in any way, it would be the exact same intervention, the same factual inquiry if I had just showed up off the street, having never been in this case at all.
I don't understand that point. You are a plaintiff in counterclaim.
Well, no longer, Your Honor, but at the time of the incident motion, I
Why
was.
no longer?
I mean, it was settlement, the case settled, I suppose. I'd be happy to disclose my motives. I mean,
The underlying case is settled?
my counterclaims and cross-claims have settled between the parties. And those cases have been dismissed by joint stipulation.
And so you're trying to intervene into a case that's been settled and dismissed?
No, Your Honor. So that's, Mr. Leaf had 3 counts to his complaint, 1, 2, and 3. I was a party only to count 3, and that was dismissed. And I would like to be a party to counts 1 and 2, which I never was.
But you have counterclaims and cross-claims. That has nothing to do with counts 1, 2, and 3. And one of your counterclaims, is for a declaration that, I'm going to read it. Plaintiff possesses no interest in defendant's real properties of 2 Driscoll Way, 6 Driscoll Way, or Driscoll Way. Why isn't that exactly what you're looking for?
Because of exactly the reason the judge says later on the transcript, when I attempt to attack the validity of the contract, and I was not literally moving for, I guess I actually was at the time moving for that declaration. He told me I did not have standing because I'm not a party to counts 1 and 2 because I never was.
Then you can appeal that when that goes to judgment because that's wrong. You have a counterclaim asking for that declaration. And if to the extent that declaration overlaps with your claims about what the contract does to you, the declaration is something that you have asserted as a party.
Yes, Your Honor. So there's more to intervention than.
Are you also telling us, by the way, that these claims have been dismissed?
Which claims, Your Honor? I'm sorry.
The claim I just read to you for a
Your
declaration.
counterclaims.
Yes, Your Honor, that's correct.
Your counterclaims have been dismissed?
Yes.
Voluntarily by you?
Yes, Your Honor, that's correct.
But the underlying suits against you and, I'm guessing it's your brother?
My father.
James? Sorry. The underlying claims by Mr. Leaf against James and you is still ongoing?
No, Your Honor, I have no involvement in this case at the moment whatsoever.
So I guess I'm going to go back to Judge Englander's question. You're trying to intervene in a case that you have nothing to do with?
No, I'm sorry. I mean, I have nothing to do, like, as far as the record, I'm not a party in any capacity. That's what I don't mean factually I have no involvement. I mean, on the docket, I have no participation.
So what's wrong with me thinking this? You were a party, you had asserted a claim that is exactly the claim that you want to intervene to assert. You've chosen to voluntarily dismiss it. Therefore, we should grant you no relief on this appeal. What's wrong with that?
So, Your Honor, what's wrong with that is that requesting a declaratory judgment is not the same thing as actually going to trial and cross-examining witnesses and attacking James Driscoll's affirmative defense that I'm a party to this contract.
I don't understand that. Just as a lawyer and a judge, I don't understand that position. Why not? You have a claim. You had a claim that asked for a declaration that I've just identified and asserted a basis for it, which I believe is there's this contract out there between my brother and the plaintiff. Why wouldn't, in the context of that request for declaration, you be unable to litigate exactly the same issue?
Thank you, Your Honor. I mean, first of all, the judge said as much, that they are separate trials. I will not be a party to the main trial of Leaf
Where
v.
did the
Driscoll.
judge say that?
It may have been in a separate hearing. He says unequivocally that I do not have standing.
Which judge said this?
Gilday in the instant.
What page are you
Transcript.
looking at in the record?
I believe it's page 69 into 70 on the record appendix. He says,
On which index?
in my original volume 1, page 69 of the record appendix at the bottom of the page, he says, what standing do you have to challenge this contract? And that was at the time both my claims, my counterclaim and my cross claims were live. And because they are completely different, they were for
That question is, what standing do you have to challenge the contract? That's different from, I would like to assert that there's nothing that grants any real property rights over 2 Driscoll Way, 6 Driscoll Way, or Driscoll Way, which I understand to be your position in this case.
Oh, yes, I vehemently disagree with that, Your Honor. Okay. And I would refer you to, I would direct you to the sworn testimony of Mr. Leaf, the appellee, and his counsel, who repeatedly say under oath, 2 Driscoll Way and 6 Driscoll Way are the subject of this litigation. And there's a good factual basis for asking, for example, if somebody leaves a car in my house at 2 Driscoll Way over 1,000 feet from 10 Driscoll Way that they now claim has no basis in this litigation.
Can I just...
Yes, Your Honor.
I am ordinarily, and I understand your pro se, would have expected someone to notify the court of a settlement that withdrew the counterclaims in this case. Who was that? Was there a settlement agreement associated with that?
I mean, not per se, Your Honor.
What?
Nothing in writing, Your Honor. It was very casual. There's a joint stipulation of dismissal with the court.
Down below?
Pardon me?
Down below in the trial court, there's a joint
Correct, yes. There's a joint stipulation, Michelle. I believe it's dated
All right,
April 1st.
I just want to look again at the record reference you gave us, because I didn't see a ruling on standing there. I saw a question from the judge about standing.
Yes, I agree. I had to infer
But
that since there was no decision.
that's what you're representing to us, was a ruling saying that you had no standing?
That's correct, Your Honor.
Okay.
Well, yes.
I'm sorry to keep beating a dead horse,
No,
the
please.
expression is. You jointly agreed to be taken out of the case entirely, correct?
Your Honor, I voluntarily dismissed my affirmative claims against Mr. Leaf for theft of property and tortious interference and other things like this.
Okay, so I'm just trying to clarify it. So the stipulation only goes to the counterclaim?
Yes, sir, expressly.
So you are still a defendant in the underlying action?
No, sir, hence the intervention.
No.
Wait, what happened to, you were a defendant on count 3?
Yes, Your Honor.
What's happened to count 3?
It has been dismissed.
As part of the same stipulation of
No, Your Honor, it was
dismissal?
dismissed forcibly by the
It
court.
was dismissed on the merits or something?
Yes, Your Honor.
Okay, so that was dismissed, and your counterclaims were subsequently dismissed
Voluntarily.
voluntarily. So right now, and is the case still pending down below?
Yes, Your Honor, it is going to trial in 12
Okay,
days.
so if there was any, what?
Going to trial in...
It is beginning trial in 12 days.
Okay, so essentially, I mean, I think you're out on the claims that you voluntarily dismissed. I mean, that's
course.
that. And on count 3, you're a dismissed defendant, but you were a defendant in the case. And if you see there's any error in that dismissal, I don't think that's part of this. That would be a part of some appeal, perhaps, after there's a final judgment. So I'm not really sure what we're doing here.
Okay, I believe I understand what you're looking for. The contract on its face says that my property is going to be affected by this deal, this contract between Mr. Leaf and James Driscoll. They have
Is the
undertaken.
contract in the record?
Yes, Your Honor, it is.
And when you say it's going to be affected, what does it say?
It says, this is subject to seller or successors not storing any boats, vehicles, heavy equipment within land that I own, property that I own. Mr. Leaf has contracted to re-gravel the driveway that I own and James Driscoll does not own, and Mr. Leaf's sworn testimony that attorney...
You're not a signatory to the contract, right?
I was supposed to be, but I did not sign, Your Honor. And then they sued me because, to quote Mr. Leaf, in order to...
So here's another
because I
thing that's
refused
occurred to
sign.
me as we're talking through this, and it's this simple. We're a court that reviews for error. On the record before the judge who denied your motion to intervene, you had a counterclaim in front of him that actually raised these same issues. Why isn't that the end of the story for us? There was no error by the judge in denying intervention because at the time that he made his decision, he was absolutely right. You were already a party and in fact raised these issues. Why isn't that the end of the story?
That's not the end of the story, Your Honor, because the judge specifically says in the transcript that I do not have standing to challenge the offer to purchase.
Will you tell me where that is?
Yes, that is in page 69, the bottom of...
I want to turn to that.
It is the bottom of page 69 in my first volume of the record
Does
appendix.
not make that ruling.
I agree he does not make a ruling.
Okay, so you cannot tell us things that are not true.
Okay. That's why I hesitated.
Take that as a general rule. I understand are you still a law student?
Yes, Your Honor.
Okay, so let's take that as a general rule for the rest of your practice.
Yes, Your Honor. That's why I hesitated. I wasn't sure if we were fixated on the word ruling. I'm not trying to assert it's a ruling. I'm just trying to get into the subjective
Saying that the
thought process
judge
of the judge.
said that you had no standing, but the judge did not say that. I have the page right in front of me.
Yes, Your Honor. I believe he suggested.
He asked you a question, what standing do you have?
Yes, Your Honor. And I believe that's related to earlier in the case.
I don't think you're really going to help yourself if you continue down this road.
Yes, Your Honor.
So I want to make sure that I'm on the same page as you. The complaint that we're talking about is on the record appendix. It's starting at page 107. You are listed as a defendant, James Driscoll and Michael Driscoll. Correct?
I'm not at the time of the motion to intervene, Your Honor. I was not.
So you were. So when did this complaint come into being?
This complaint came in. Okay. Pardon me, Your Honor. So, yes. So this complaint came into being on June. I was not aware that I had to. That was not the pleading I actually intended to use if the judge granted intervention. It was to give him an idea, since I did not include a proposed complaint in my Rule 24 motion. So, but the thrust of the argument was that because this contract, as everybody has agreed, is going to affect my property, because they expressly say they wrote the contract to affect my property, that I should have some say in it. And since, because I did have say as a defendant, I was then dismissed. And now, just because I didn't agree to do this stuff, they can go do it behind my back. And I said I should have that intervention. So I'm saying that because just because I didn't agree to it doesn't mean that it's not going to happen to me, because they are still both adamant that they are going to affect all of my property, Your Honor.
I think we understand your argument. We'll have to take the rest of it as from your brief. Let me see if there's any other questions. No. Okay, thank you. Your time has expired.
Good afternoon, Your Honors. May it please the Court, Kathleen Heyer on behalf of Appellee Robert Leaf.
You may want to move the microphone and also speak up.
Do we have both parties here? So do we also have the other Mr. Driscoll's? Are you? No, you're just Mr. Leaf. Okay.
I don't. Mr. Leaf is not in the courtroom, Your Honor.
No, I know, but just counsel for Mr. Leaf, right?
Oh, yes.
You're both counsel for Mr. Leaf.
Correct. Your Honors, this matter is Michael Driscoll's appeal of the trial court's denial of his motion to intervene in a case in which he was already a party. The underlying litigation concerns a contract to purchase real estate between Robert Leaf and James Driscoll. Michael Driscoll is not a party to that contract. He was not a signatory to that contract. He was not anticipated as a signatory to that contract. The contract is in the record as Mr. Driscoll noted, and you will see that there is no signature line for him there.
Does the contract have, I should know this, but does the contract have provisions in it that would include doing work on Mr. Driscoll's property?
No, Your Honor. And to the extent that Mr. Driscoll reads the language in the contract as possibly implicating his property, Mr. Leaf has also waived all of those contingencies as part of his specific performance claim because that's the basic contract action underneath.
The complaint that the judge wouldn't allow him to intervene in, or denied his motion to intervene, is that the complaint on page 107 of the record appendix that says amended verified complaint?
Yes, Your Honor.
So he's listed as a defendant in that, correct?
Correct.
And he suggests that the judge in questioning was questioning whether he had any standing to argue anything regarding counts 2 and 3.
1 and 2, I believe, Your Honor.
Okay.
Count 3 was brought against Michael Driscoll under an apparent authority argument. He successfully moved to dismiss that, thereby nullifying that. I believe he's asking the court to find that he has standing to participate in a contract action where he's not a party to the contract, nor is he an intended third-party
Oh,
beneficiary.
he's worried that you guys wrote a contract that affects his property. And you tell me, no, it didn't, but it does say something like, I mean, it seemed to read it in both your briefs. It says something about having to remove chattels or something like that from along Driscoll Way, right?
Your Honor, our position in the underlying litigation is one that was a personal promise on the part of James Driscoll and therefore does not implicate Michael Driscoll's property at all. And also, as I said, our client has waived all of those contingencies on the second page of the contract to move forward with.
Well, if the contract is specifically referring to his personal property, it surely implicates his property. Understanding the legal point that you're making, I thought I asked, does it implicate his property? And you said no.
There is no indication in the record, Your Honor, that the property that's being spoken of belongs to Mr. Driscoll, this Mr. Driscoll. Our client's request was that James Driscoll remove items that belong to James Driscoll from the real estate to be purchased. And to the extent James Driscoll has control over other property, possibly from that as well. But again, we've waived that.
What's the status of the counterclaims?
Michael Driscoll's counterclaims, he's stipulated to a dismissal of those, I believe, April 1st last
That
year.
pursuant to a settlement?
There's no written settlement.
Did you know in advance that he was going to dismiss?
I personally did not. I can check with my co-counsel who was
Well, was
counsel at the time.
there negotiation between your client and Mr. Driscoll before there was a dismissal of his claims?
I don't believe so, Your Honor. I believe we filed a motion to dismiss under Rule 9A, and shortly thereafter, they entered into a stipulation of dismissal.
Thank you.
So what is left? Michael Driscoll, to make sure we're clear, says that there's a trial coming up. What claims are left for that trial?
Our client has a claim for specific performance relating only to 10 Driscoll Way, which is owned solely by James Driscoll, and James Driscoll has raised a breach of counterclaim, which will also be tried as part of that trial that starts on the 23rd.
So going back to the complaint that I referenced earlier, count 1 is still in play against James Driscoll.
Correct, Your Honor.
Counts 2 and 3 are out. For whatever reason, motion to dismiss, stipulation, those are gone.
Count 3 is out. I believe count 2 was an injunction, which is more properly a remedy than a count. So to the extent that we received a lis pendens on the property, the injunction was probably not necessary.
So do you believe that at this trial that's upcoming, Michael is no longer a party to that case at all?
Yes, Your Honor.
So does he now have grounds to intervene because he says count 1 interferes with his property and that contract does affect him?
I don't believe the court needs to reach that issue, given the stricture of the motion to intervene, which was, you're looking at as of the date he filed the motion to intervene on December 29th, 2021. But even that being the case, I do not think that he has any right to participate in a breach of contract action that is solely between two other parties relating to property that he does not own.
Unless it affects his property, because then he has a right as an intervener that the contract between the two parties may have effect of his property.
Your Honor, I believe if we are successful in the underlying litigation, we will receive an order from the trial court directing James Driscoll to convey Lot 10, which Michael Driscoll does not have an interest in, to our client Robert Leaf. There will be no order or judgment that impacts 6 or 2 Driscoll Way at all.
Well, rather than getting to this point through what you believe the judge might do, are you willing to represent to us in open court that you will not seek any such relief as a result of the trial down below? That you would not seek relief pertaining to anything other than the conveyance of, is it Lot 10?
Lot 10, yes, Your Honor. Yes, we're not seeking any conveyance of rights in Lots 2 or Lot 6.
And you won't,
only
or
Lot 10.
performance of anything with respect to any other lot, like removal of property, you will not seek that relief at all?
All of those items that were listed in the second page of the contract have been waived. We're not moving forward on those.
Okay.
Does anyone have questions? Do you have any questions?
No.
I don't see any other questions.
I don't have anything further to add, Your Honor.
Okay.
Thank you.
Thank you both. Thank you both for your arguments, and the case is submitted. The next case is 2021 P1146, John VEIRA versus John Alexander. Mr. Vieira, I'm sorry if I mispronounced your name.
No, you
Would
correctly
you correct me?
Yes.
Thank you.
Well, good afternoon, Chief Justice, Associated Justices. My name is John C. Vieira II. I'm a pro se, and I'm the appellate.
So I appreciate the elevation, but I'm not actually the Chief Justice.
I thought the Chief Justice was in the middle.
I know, I'm the Chief of
And then it went seniority on each side.
You're absolutely right, but and there was no reason why you would know this, but I'm just the chief of this panel. I'm not the chief of the entire court.
Okay, Your Honor. I'll address you as Your Honor.
Thank you.
I'd like to begin my oral argument with my bullet points on my brief and appendix. Massachusetts General Law, Chapter 268, Section 1, perjury, makes it a crime to mislead, make false statements during a court case, or other legal proceedings. I ask the honorable panel to analyze my bullet points and determine if there was permissible or an act of perjury by the appellees. First, I will prove how Barnstable Police Officer Anderson Moore used his position to falsely arrest me, falsely imprison me, and with malicious prosecution, making numerous false statements, should discredit the probable cause when he arrested me with all his false statements. Second, I will prove Chief Legal Counsel Bradford Lewis, for the appellees, made false statements during the summary judgment hearing, claiming the criminal charges against me was dropped due to my wife's refusal to testify. Third, why I believe Judge Perano should have recused himself from the civil case due to being a first clerk for the Barnstable Clerk Magistrate prior to being a judge. And I know you people are judges, and you guys are very like a brotherhood, sisterhood. But I believe that Judge Perano should have recused himself by being the first clerk for years with the clerk magistrate in the same building he's presiding in.
Let me ask you a question.
Sure.
So, the argument you raised in your brief is as follows. There must be checks and balances for a rogue Massachusetts law enforcement officer using the power of the badge to proclaim probable cause in an arrest.
Correct.
And I
But there's-
I recognize your pro se, so I am trying to understand that within a more traditional legal framework.
Your Honor, if you could
So-
let me continue just a little further.
Sure, but let me ask my question first.
Okay.
Okay? So what I think I understand your argument to be is the following. That when the officers responded in response to your telephone call,
Which was a community service call.
okay, sure, they should have done something differently. And if they had done that something differently,
Not they, just one.
okay, if one had done something differently,
Correct.
then there wouldn't have been probable cause, because they would have been able to ascertain the information and what was really going on more accurately.
What I'm stating is that how can there be probable cause when our constitutional forefathers made checks and balances where one person, no king, no ruler, can make a decision by his own mind with no evidence and have probable cause? All Officer Moore had to do was go to Officer Franchio and say, corroborate that story. He didn't. He took everything upon himself.
Okay, so let me give you a hypothetical.
Okay.
And the reason why I was asking you the question to try to clarify that for me is checks and balances is not usually a concept used in this context. It's usually used in the context of different branches of government, checks and balances that way. What I think you're arguing is that the officers, in the way that they conducted themselves at the time when they responded, was such that because they shouldn't have relied on the information they got without verifying it in some ways.
An individual. And what about phony police reports?
Okay.
Is there anything involved with that?
So if let's say someone calls police to a scene of something, just anything, this is the hypothetical.
Okay.
Just a person calls and says, come to, the corner of
For a community service.
Elm Street and Main, there's a problem here.
Right, there's
And
an
they
argument
come,
here.
And they come, and I'm going to ask the hypothetical. You don't need to modify the hypothetical. Just wait till I get to the end of the
Okay.
hypothetical. And the officers come, and they talk to a witness, someone there. And the witness says, I saw ABC.
Where did the witness say that in this case?
Okay, so, I'm just saying my hypothetical. And the officer,
Yes.
and the witness says, Officer, I saw ABC. And the officer accepts that and then arrests a person. Okay? You got my hypothetical?
I got your hypothetical.
Is there some case law that says that the officer can't take the statement of a witness at face value when
What
deciding?
statement?
When
Where is it
decide-
in the record where there was a statement by someone that a crime occurred? That's my question. And why is, what?
Well, I can answer that question.
I'm a pro se, and I've been up for like 7 days trying to present myself to this majestic panel. Okay.
So I can answer your question if you want us to.
Yes, please.
All right. So I'm looking at the police report.
You're looking at two police reports.
Well, I'm looking at
You're
one.
looking at one when my arrest was made, and then you're looking at one after I filed my civil suit.
I'm looking at
You're looking at two police reports. You're looking at an alternate, false, phony police report on September 23rd, 12 days after I filed my civil suit.
So
And which states that I was intoxicated and that I abused a child. My son was 20 years old, 6'6", 235 pounds of pure muscle.
Well, the one I'm looking at it, and if you'll allow, see, we can't learn if you don't let us ask the questions. Okay? This one, it says it was entered 7/12/2018.
That's correct.
Right, and
That's the first one.
modified the following day. And it says, both Ms. Lorraine and her son gave the same account of what occurred. And it goes on to say that mother and son report that son was sitting on the couch and dad was standing over him yelling at him. He said that his father then picked up his own cell phone and yelled, "Here, why don't you use my cell phone too?" He threw his phone, demonstrated by mother as an overhand motion, and it struck his son in the hand. Now, when you say, where is the evidence that you committed a crime, that is the evidence that someone could rely on for an assault and battery.
Your Honor, what about the evidence where the officer says he went into the residence and my wife signs an affidavit stating he didn't? What about the evidence with a second police report that's changed the entire scope of what occurred that day? Probable cause is so abstract. I could throw it in the air, and you could come up with something, you could come up with something, and you could come up with something all different.
You know what our cases say is the definition of probable cause?
What?
I'm asking you the question.
I'm saying it's abstract. It's on an individual case. You can look at probable cause one way, you can look at it another way, you can look at it another way.
What have our cases said? Do you know what our cases have said as the legal definition of probable cause?
I do not. What's the legal probable cause?
That's all right. We don't generally answer the questions.
Oh. I can already see that. I'm not going to go anywhere. Thank you for your time.
All right. Let me see if there are any further questions for you. Do you have any questions?
I don't, no.
No. Okay, thank you.
Thank you.
We're going to hear now from the other side.
Do I have to stay?
Yes, it's generally our common practice that we hear each other's sides' arguments.
Good morning, Your Honors, and may it please the Court. My name is Elizabeth Sine, and I represent the defendant appellees, Officers Anson Moore, Officers Dennis Frankio, and Sergeant John Alexander. This Court should affirm the Barnstable Superior Court's decision granting the appellee's motion for summary judgment and denying the plaintiff appellant's post-judgment motion for relief. First, the summary judgment record demonstrates that there was probable cause to arrest the plaintiff appellant.
Well, I'm a little confused. What were the claims in the complaint?
Yes, Your Honor. Count 1, false arrest. Count 2, malicious abuse of process. Count 3, false imprisonment. Count 4, malicious prosecution. And Count 5, what the court treated as an intentional infliction of emotional distress.
Right. So I take it that your position is that a necessary element of all of these claims is that there be a lack of probable cause?
Your Honor, our position is that the existence of probable cause
was a necessary element for all of the claims?
The lack of probable cause was a necessary element to Count 1, false arrest, Count 3, false imprisonment, and Count 4, malicious prosecution.
Okay.
Not for intentional infliction of emotional distress.
Correct.
And what about Count 2?
Count 2, malicious abuse of process. The principal ingredient to one of those claims would be the improper purpose in initiating the process against the plaintiff appellant here. And so we would argue that the existence of probable cause for Count 1, 3, and 4, and the lack of an improper purpose or any evidence of an improper purpose in initiating the arrest of the appellant defeats Count 2 and Count 4.
So you say there's nothing in the record that indicates an improper purpose because there's nothing that indicates that Moore knew the appellant beforehand?
So there's a couple of different reasons, Your Honor, yes. So An improper purpose has been defined by the case law as using a court proceeding, or in this case, an arrest, to gain a private advantage because of hostility, ill will, without belief by the accuser in the guilt of the accused. Here, Officer Anson Moore, there's absolutely no evidence in the summary judgment record that he initiated this arrest with improper purpose. On page 139 of the supplemental...
How do we, it seems to me a person's purpose, you know, what's in their head, is extremely fact-dependent and fact-intensive. How does that get disposed of on summary judgment?
Because there were no facts. There was zero facts that the appellant has offered on the summary judgment motion, or rather to defeat the summary judgment.
I think what the appellant is arguing is that the way they conducted this investigation when they showed up, i.e. they didn't investigate, bears on the officer's mindset. And that might be, I'm wondering if that might not be enough to get him over the bar on summary judgment as to purpose.
So if we unpack that, stepping back to the probable cause determination, Officer Dennis Frankio is the responding officer. He gets the call first. He arrives first. He's speaking with the plaintiff appellant on the date of the incident outside the home. Officer Anson Moore then also responds. While Officer Dennis Frankio is speaking with the plaintiff appellant, Officer Moore goes and speaks with the wife and the son. When we look at the son and the wife's deposition, page 189 through 90 of the supplemental record appendix, the son confirms, he testifies, the officer asked him what happened, and he explains that after a 12 to 13-hour shift at work, he arrives home, he's confronted by the appellant who initiates, quote-unquote, a very vicious argument, which the appellant does not dispute. He did not dispute that in the summary judgment record. Very vicious argument is initiated.
So is the point here that they had probable cause to do the initial arrest?
Yes. Yes, Your Honor.
But I think maybe Judge Wolohojian is asking, is that enough? Does the record also have in it the statement from Officer Moore to the plaintiff, you're really screwed now because you're here overnight? Is that in the record?
Your Honor, the plaintiff appellant, I believe, testified to that, alleges it in the complaint. However, he alleges a lot of things.
Well, wait a second. If we're going to rely on the statements made by the son and the wife for purposes of a probable cause, I think we're entitled to rely on the statements of the plaintiff for determining whether he's put in enough to create a genuine issue of material fact.
Sure. So if we take a look at
So we're going to accept that as true, that Officer Moore said to, unless you tell me there's some reason I'm not going to accept that as true, like he said something absolutely the opposite in a deposition or something. So Officer Moore says to him, you're really screwed now. Is that an indication of an improper purpose, potentially?
No, Your Honor. Let's take this as true, that Officer Moore says that to him. The plaintiff appellant has also suggested that the appellant said something to the effect of, or that Officer Moore said something to the effect that the appellant was a homemaker. He says that. Let's take that as true.
Well, we know that's true. It's in the booking document.
Yes.
Okay.
Let's also take true, which I believe Officer Anson Moore acknowledges in his deposition, that he did not get the appellant footwear on the way out. He was relying on Dennis Frankio to get that because he was staying behind. Taking those facts as true, the case law is clear that wanton or negligent behavior, which arguably, let's assume we have that, wanton or negligent behavior, insufficient to demonstrate improper purpose without an ulterior motive. We have no ulterior motive here. The appellant on page 139 of the record appendix.
Would it be an ulterior motive if the officer has just decided he doesn't like the plaintiff, and he wants the plaintiff to suffer by having to sit in jail for a day?
There's no facts in the record to suggest that he doesn't like
You
the
don't
appellant.
think that it can be inferred from the "you're really screwed now" that he doesn't like him?
No, Your Honor. In fact, the appellant suggests he has no prior interactions with Officer Moore. He has only quote-unquote suspicions, beliefs, and opinions that Officer Anson Moore has some sort of personal vendetta or revenge theory against him. He admits this in his deposition. He has no facts supporting that.
I wouldn't think that it would be a common practice for a police officer to make that kind of statement to someone that they've just locked up overnight. And I certainly wouldn't want to defend it as appropriate police behavior, right?
Certainly.
Okay. So we have a situation where we have in the record a statement that's made that suggests dislike.
What about releasing him barefoot?
Your Honor, this was a separate set of officers that, I'm sorry, could you rephrase your question? Do you mean releasing him barefoot for the arrest or to court the next morning?
Well, any of it. I mean, any of it. What you're arguing, I think, is that the plaintiff did not raise a triable issue of fact as to purpose.
Yes.
You would have to agree that we would consider both direct evidence of purpose and circumstantial evidence. So it doesn't have to be someone saying, I had a bad purpose. It could, as long as there are circumstances from which a juror could reasonably infer a bad purpose, then the plaintiff would get to the jury on that. And I'm just, along with Justice Englander, asking you about some facts that we think maybe are enough to get the plaintiff over the bar on the question of purpose. Because they have the statement that you're really screwed now or whatever it is. There's maybe the fact that they just ask two people and they don't get a second point of view, maybe. They hold him a long time. They release him without shoes. They take him to court without shoes. Doesn't look like ideal police work.
Your Honor,
if we take these things at face value, and if the plaintiff can prove them, et cetera, et cetera.
So improper purpose or evidence of malice can be inferred, however, can be inferred generally, not in this case. However, to succeed, the plaintiff has to demonstrate a link between that conduct and evidence of a spiteful purpose. It's extremely important to note that in this case, the arrest was mandated. Essentially, Officer Anson Moore, his hands were tied. He had to arrest the appellant once the probable cause was established.
I saw that argument in your brief, and I went and I read the statute, and I asked myself, if the statute says preferred, that doesn't mean mandated.
Well, its arrest shall be the preferred response.
I think it says shall in connection with a situation where there was already a prior order, and it says preferred in a situation where there's not. But I don't have it in front of me, and I might be wrong, so correct me.
Court's indulgence. Let me just pull this up.
What page are you looking at so we can all look at it together?
I'm just looking at the language of the statute.
Right. I assume it's an addendum to your brief.
It was quoted in, I believe, your brief.
So it states, when there are no vacate, restraining, or no contact orders or judgments in effect, arrest shall be the preferred response whenever an officer witnesses or has probable cause to believe that a person, and then it enumerates the
So it's
situation.
preferred, not mandated.
It just says it's the
Yes.
preferred.
And the reason why one might be in that position is in order to give police officers discretion to make the kind of judgments that we want them to make every day so that they don't put someone in jail who doesn't belong in jail.
Correct, Your Honor. With the enactment of that statute, the Chapter 209A, the legislature expanded the authority of the police to make these warrantless arrests where probable cause is established.
Well, counsel, again, back, and I have a follow-up, but if a police officer reports to a scene, and I will use a domestic violence case because that's what the statute talks about. The wife says, husband hit me. The husband says, the wife hit me. Are you saying that police officer pursuant to the statute has to arrest both of them?
No, Your Honor. So
they make a decision based on hearing from wife and husband as to which one there's probable cause for and arrest one of them, correct?
Well, if we just take a step back as to what was actually reported to Officer Anson Moore, we don't have a report from any witness that the son, the victim in this case, through a cell phone, otherwise caused some sort of offensive or harmful
No, I think you're missing the point of Judge D'Angelo's hypothetical in question.
You're talking about the statute, and please, I do have a follow-up, but you're talking about the statute, and both justices have asked you that that's the preferred. The statute doesn't mandate an arrest. Would you agree with that?
It's our position that Officer Anson Moore was required to arrest the plaintiff appellant under the statute.
Okay, well, this is a good segue to the follow-up. Would you agree that in the deposition of, I believe it's the mother of the son, contradicts what the son said? The son says, Dad did X, Y, and Z. Mother who's present says, I didn't see any of that. That's a contradiction in the two depositions. So when it comes to probable cause in a summary judgment action, doesn't that become a question of fact for a jury to decide? Because now you have a police officer says, well, son told me this, and son says, yes, that's what I said, but mother says, no, that's all a lie. That didn't happen. So why isn't that a question of fact for a jury to decide as opposed to a judge?
Your Honor, I don't believe that the wife testified that the son's, I see that my time is up. May I address her question and briefly conclude? The wife on page 245 to 46 of the deposition confirms that the husband, the plaintiff appellant, threw his cell phone in the context of this very vicious argument about the cell phone bill at the son, as if to say, here, take my phone if you're not going to pay the phone bill. She says that on page 245 to 246. It's also important to remember, as she acknowledges on 247 to 48, everything that Officer Anson Moore was told on the date of the incident that formed the probable cause determination was in the midst of what appellant does not dispute is a very vicious argument. When she spoke to Officer Anson Moore, she acknowledges in her deposition she was angry. When we look at the totality of the circumstances of this case and what Officer Anson Moore undisputably was told on the date of the incident, we have probable cause, and we have a lack of an improper purpose. Arrest was the preferred response under the statute. And for all of those reasons, this court should affirm.
Let me see if there are any further questions.
I'm rerunning the tape of that last. The lack of probable cause gets you past malicious prosecution, right? The existence of probable cause gets past malicious prosecution.
False imprisonment.
False imprisonment.
And false arrest.
And false arrest.
Yes.
And false arrest.
Even if there were
if probable cause existed at that time as a matter of law based on the record in front of us, right? But then we've got improper purpose and we've got emotional distress, and those you've got to win the argument that there was no evidence as to improper purpose.
I'm sorry, I'm not sure I understand Your Honor's question.
Counts 2 and 5.
Abusive process.
Correct, yes.
You've got to win the argument that there was no evidence of improper purpose.
Correct. So even if the appellant shows or proves a lack of probable cause. His claim on the malicious prosecution still fails because he also has to prove that
No,
there is
that's not my question. I'm sort of past the point of, assume that you're right for present purposes about the existence of probable cause as a matter of law. You still have to, that doesn't get you past the abusive process count or the intentional infliction of emotional distress count. I think what was your argument on intentional infliction of emotional distress? It was, since there was probable cause to arrest, and we have a law that says that they were supposed to arrest, that therefore there couldn't be intentional infliction of emotional distress because it couldn't be extreme and outrageous conduct?
Correct. So as your honors are...
Yeah, but I mean, so suppose that it was a good idea to arrest him, could it still be extreme and outrageous conduct to have him walking around in his bare feet and literally say things to him which are intended to cause emotional distress? You're really screwed now. You're stuck. You're stuck in this, in the slammer for overnight. Couldn't that be enough?
No, Your Honor. The police were acting within their lawful authority. Officer Anson Moore did attempt to secure footwear for the appellant. The appellant then, when he got to the station, admittedly just refused to call his wife or his son to come pick him up. He didn't call. The officers that took him in the morning to court and thereafter were a different set of officers. And that's all we have here. Everyone's involvement ended at the booking of the arrest.
Thank you.
Thank you, Your Honor.
All right. With that, thank you both for your arguments.
I apologize if I was a little forceful.
We understand, and it's no problem at all. I'm glad you stayed for the remainder of the argument. We have your brief. We consider all these arguments and briefs seriously, and the case is submitted. And with that, we're going... And you did a good job, sir. And we will stand in recess.